Yes.
I beg to mention one item, my lord. It is filed yesterday, my lord. So there is some urgency. It may be listed on Monday, my lord. Apologies.
Definitely, sir. I make to mention for listing one motion matter.
Ah,
Tomorrow, may
tomorrow so many. What is the urgency?
urgency will remove from the ward member.
Huh?
Remove from the petitioner
It can be restored back Monday.
Monday. And more other two requisition my lord admission matter.
Give it to the court master.
My lord, these are composite land transfer matter, my lord. It is admission stage, my lord. Instruction was sought, but still not waited. My lord.
Okay, give it to the court master. He'll fix it.
May I please, Lordship? Well, I beg to mention for listing, my lord, admission matters, my lord. Matter is, Lordship, regarding settlement of some compensation of the awarded by the National Highway, my lord, some acquisition land agreement. Then now it will be settled between the parties, my lord. So, Lordship, it may be
You want to withdraw?
listed, Lordship, for after compromise, my lord, between the
Huh?
parties.
After?
For compromise, my lord, we have filed an IA, my lord. Your Lordship,
Okay, we'll get it listed.
May it please your lordship. Lordship, I am praying for listing of this matter in the admission column, lordship. Land settlement matter, lordship, interim was granted for 4 weeks. That period is over, lordship.
Okay, give it to the court master.
Wait, I wait for listing motion matter, my lord, Monday matter.
May I please, your lordship, with the consent of the other side, I beg to mention item number 5 and 6, lordship.
Okay, Mr. K. Jain, Learned Counsel. On behalf of Mr. S.C. Kyle, the Learned Standing Counsel, GST, has made a prayer for adjournment of the cases, with the consent of the Learned Counsel for the petitioners. First of the prayer is allowed as sought for list the cases after. As sought for
After vacation,
in
lordship.
2, huh?
After vacation, lordship.
List the case after the ensuing vacation,
Much obliged, your lordship.
immediately after ensuing vacation.
My lord, item number 4. My lord,
Yes,
my senior is busy in hospital. As his family member is
hospital.
hospital, ICU admitted. One of
Who is your
the-
senior?
Mr. B. Bora, Vishwadip Bora,
You are Mr.
Surjit Sharma. S. Sharma.
S. Sharma, Learned Counsel has submitted that Mr. B. Bora, no, arguing counsel, Mr. B. Bora is indisposed and is admitted in hospital in such view. He has thus sought for listing of the case after
Any that, my lord.
2 weeks. Mr. S.S. Roy, Learned Junior Government, Good Assam, Ms. G. Hajaria, Avenue are present.
Wait, lordship. My lord, I make to mention for an admission matters, my lord.
What is the subject?
Subject is regarding land compensation, and our plea was that the opposite party, there is apprehension that the amount is given to the wrong person, my lord. That's why this case is filed. So it was about to come on last month, my lord.
Leave it to the court master.
Yes, my lord. Obliged.
May I plead your lordship? Lordship, the one, the writ petition in admission, lordship, any date may be fixed next week, lordship.
What is the subject?
Subject matter is pensionary benefit, lordship.
Oh, rejected. Go to the appropriate bench. Pension matter is not dealt by this bench.
Supplementary list for withdrawal. Item number 11.
May I please, lordship?
Yes,
For
madam.
withdrawal with liberty, lordship.
Why? Liberty, why?
Lordship, as per instruction, lordship, some development has taken place, lord.
Miss,
J. After.
you are from BTC?
BDC.
Miss J. Akhtar, Learned Counsel. Appearing on behalf of Mr. M. Khan, Learned Counsel for the petitioners has submitted that the petitioners want to withdraw this petition come out with liberty. Mr.
P. Bhumik on behalf of AK Bhuya.
Okay. Standing Counsel, BTC. 4, 5, 6, 7. G. Hazarika, Standing Counsel Revenue. 1, 2. S.S. Roy, Junior Government Advocate. 3 are present. In view of the above submission made by Ms. So and Counsel for the petitioner and repetition is dismissed and withdrawn, come out with liberty. As prayed for.
For motion, item number 12.
Yes, anything on law?
My lord. But the petition, my lord, if your lordship petitioner does not have any power to file a repetition, this is the first submission. He does not have any
It-
power, my lord.
Is it in the
Yes, my lord.
power of attorney?
Yes, my lord. He will submit, I'll submit on that, my lord. And what is the definition of power of attorney? That has been in section 1 of the Power of Attorneys Act.
Where is the power of attorney?
My lord, first power of attorney, my lord, lordship will look into, my lord, page 63.
63.
There is a first power of attorney.
Lordship, that was a joint power of attorney. Then later, individual power of attorneys were also executed. Lord.
Lordship will look into first, my lord, that one, my lord. What are the clause, my lord? What are the powers? That is special power of attorney. And the executant is all the power person, my lord, repetition. There is no power in this attorney, my lord, to file a repetition,
Hmm.
only to receive the compensation amount.
63.
63, my lord, 63 and 64.
Let us see the clauses. Do the following states to engage any executive one to sign the department,
First-
sign to the department, draw compensation amount to settle any dispute, legal matter, legal. By any stake, any connection with our matter. Yes, any other power of attorney here?
And then, my lord, next power of attorney, my lord, that is, my lord, lordship will look into the who is the executant and who is the attorney, my lord. There's a three of the persons, 5 persons represent have signed the, my lord, executant. In
No.
this part, there is no power, no attorney to file a repetition.
There is,
Next, 67, my lord, 68.
let us see,
Next, the 68, my lord.
Ujjal Grow.
Ujjal Crow.
He's a
I should-
petitioner, he's a petitioner.
Yes,
Petitioner, my
Lordship.
lord. Petitioner number 1.
Petitioner number 1.
I should appoint an attorney to represent me before the concerned authorities. Nominate so and so as my attorney for. First, to represent me in before the appropriate authority and any other court where the suit is or petition is filed. And conduct the suit, petition or appeal in accordance with the laws and procedure of the relevant jurisdiction. That is the power.
But she is there,
My lord, then lordship can look into
three.
3, my lord. Yes, my lord. To prosecute the case, suit, petition and all related proceeding, including filing pleadings, motion and applications. Then lordship will come to the page 70. Who is the executant? Page 70. Executant is the person Avinash Ranghang, my lord. On that basis, whether the petition can be filed. And the attorney holder is Ujjal Crow. In all the power of attorney holder is, my lord, attorney holder is Ujjal Crow, executant is Avinash Ranghang. And the definition of power of attorney is under section 1 of the Power of Attorneys Act, my lord. The Avinash Ranghang cannot be the executant, my lord.
You cannot give power of attorney
But to
yourself.
them, Ujjal Crow is the lead petitioner.
No, by this, it means that Avinash Ranghang is giving the power of attorney to himself.
My lord,
Himself.
himself, my lord.
It has become the opposite, Lordship. Opposite. The Ujjal Crow, it should have been Ujjal Crow who should
No,
have been.
we have to read, we have to go by
Yes,
what
my
is
lord.
there.
What is
Yes,
the document
lordship.
We
annexed to the
cannot read
petition?
something
Yes, Lordship. I'm
which is not
admitting-
there.
Yes, Lordship. I'm admitting, Lordship.
This is not correct
Yes, Lordship.
form of power of attorney.
Yes.
And by this power of attorney, the petitioner filed a writ petition claiming that he should get the power of attorney holder should get the compensation.
That
To
is
the
a
highest,
different matter.
my lord.
But the way it has been executed is
My
wrong.
lord, wrong, my lord. It cannot be, my lord. So on that basis, my lord, writ petition cannot be filed. on this, on the basis of this power of attorney holder, power of attorney, my lord, special power of attorney.
Execute.
And yesterday, what your lordship observed, my lord, judgment is there on that, my lord. Pleadings, my lord, what your lordship observed yesterday, my lord, that it should be in the knowledge of the, my lord, attorney holder, then it can be only. The judgment is there on that point. But it is-
Otherwise,
My lord,
suit can be filed, complaint can be filed,
My
criminal
lord.
complaint can also be filed.
my lord, my lord.
But it has to be, he cannot step into the shoes. Suppose a person has been beaten up.
My lord,
He likes to file a complaint.
my lord,
When he gives a power of attorney.
my lord.
Power of attorney files the complaint,
Mm,
right?
My lord.
And he said, I have been beaten up, so that
My
will
lord,
not do.
that is a settled position, my lord. But in
Personal
this-
knowledge.
My lord, but in this case, my lord, when he does not have the power, my lord, to sign and swear the affidavit, my lord, the repetition is liable to be dismissed.
This is wrong. Mr. Kathar,
Yes, Lordship.
this is wrong.
Lordship, I admit that on both the points, the council is
This
correct,
point,
Lordship.
We are not foreclosing your right.
Yes, Lordship.
But the way you have filed,
Yes, Lordship.
this is not to be.
The power of attorney also, Lordship, I have only seen it now only, Lordship.
Uh-huh.
It is wrong, Lordship.
You should have exercised care and caution.
Yes, Lordship.
This is wrong because definition is there
My lord,
and execution under power of attorney.
my lord.
So
They have signed
the
it the wrong
sites are
place.
wrong
Yes, Lordship, they have signed it the wrong
and we
place.
cannot go on.
Yes, Lordship, we
It-
cannot go on
It's
that.
up to you.
Lordship,
We otherwise dismissed.
Lordship may give me liberty to file afresh, Lordship.
It is up to
The
you.
petitioners, they will
He can come
file
definitely.
themselves. Yes, Lordship.
That is a different thing, but not through power of attorney with a power of attorney of this kind.
Incorrect is, Lordship, it is incorrect.
Yes, we will close this,
My lord, my lord.
but liberty should be there. If they have a grievance, they
The
can come.
petitioner, liberty may be given to the petitioner, my lord, not to the power of attorney holder. And my
I
lord,
think I'll not observe that it is,
Yes.
my lord, and
it is a
that
wise
one,
sense
my
of
lord, the
Mr.
petitioner,
Kathar.
Lordship, I have already
comes-
spoken, Lordship. I have
the
already spoken.
petitioner, all the petitioner have received the compensation amount, then they have filed the undertaking also.
Additional-
They have not mentioned here in the repetition, they have not stated anything in the.
By a proper one.
Yes, Lordship.
Mr. J.I. A.I. Kathar, Learned Counsel for the petitions, has submitted on instruction that the petitioners, on the read petitioners, in whose names, comma, or in whose names the read petition is filed, comma, want to withdraw this read petition with the liberty to file afresh. But Mr. Jay Sutia, Learned Standing Counsel, AAAC, has pointed out that there is a defect. This writ petition is preferred through a power of attorney, and there are defects in the power of attorney. Full stop. Be that as it may, full stop. In view of the submission made by Mr. Kathar, the writ petition is dismissed on withdrawal, with the liberty as prayed for. Be careful.
Yes, Lordship. Obliged, Lordship.
Bartlett matter for admission, item number 1.
But I'm extremely sorry to make this prayer, my lord. But I could not prepare the case properly, my lord. Today morning I started, my lord. It's a contentious issue, my lord.
It is contentious.
Yes,
Though
maybe-
it looks like very small.
Small. I tried from 6 in the morning. I started, my lord. I could not complete. So may I pray next Thursday, my lord?
Because otherwise, I don't know, but because it is a vexed issue.
Yeah.
Royalty
Yes.
must have a source. Like though royalty is not tax, but must have a source.
Master resource.
MMDR Act says these provisions for minerals are not applicable.
Yeah.
So state government has the power
Yeah.
for minor minerals.
I know.
Let us admit ordinary art is minor mineral. For a moment, for the
Minor.
sake of argument,
My lord.
you have framed the law, rules,
2030.
then you amended it subsequently. Maybe a conscious omission or I don't
True,
know.
my lord, true. And there are judgments, my lord, not exactly on the point judgment. There are several judgments, my lord.
But that provision is not discussed.
Is not discussed. Although,
Right.
and there are judgments
Rule 27 is not discussed.
not discussed.
So, prima facie, it can be observed that those are par incurium.
Sorry.
If that
Yes.
is correct, then it will stand on its own,
Yes, ma'am.
right?
I got it, ma'am.
And there is a gap period,
Yes, ma'am.
13 to 21,
21.
0.
19, it was concluded. Contract was concluded in 19.
Prior to that, it was concluded.
Concluded.
Everything was in between that.
Yes.
Now, if you go to MMDR Act again, you can realize royalty. But what royalty you will realize? I don't know. Maybe
I got it, my lord.
queries are very
got it.
innocuous. Very,
One of the anxiety that I am having is that, my lord, if we allow this writ petition, my lord, if this is allowed by your lordship, my lord, this will have some precedential value. And on this issue, my lord, there are several judgments, my lord, little bit deviating from each and every judgment, my lord.
every judgment is
Little bit
confusing.
Deviation, my lord.
Every judgment is confusing.
Yes, there is a judgment of division bench wherein said that even from a private patta land, royalty is to be paid. Then
Yes,
the forest regulation comes. Then again, my lord, I mean, the MMDR Act and the rules come.
and you have brought in that mining plan is required.
Yes, ma'am.
But your form does not say so.
Yes, ma'am.
You have brought in a new concept,
True, my
which
lord.
is not there.
It's a very contentious issue, my lord. I need some time, my lord. Next Thursday, my lord,
So-
definitely do, my lord.
I was initially thinking why I am taking so much time. Right.
Yes, my lord.
That council will think that court is also confused. But I am not that confused. You have given me so many judgments.
My lord.
All are not
Not on the point, my lord.
and not consistent also.
Not
To be
consistent.
fair,
Not considered. Recent judgment says there has to be a clause in the contract.
somebody said that has been deferred by
Yes, my lord.
other division bench. So I got confused with those judgments.
That's why,
Then
my
I
lord.
saw that none of the judgment, Rule 27 is there.
Yes, sir.
So it may be a par incurium judgment, all those. And to say
The impact
for a
that this-
single judge, to say those division bench
that
judgment
is
par
also difficult.
incurium, that is also
Yes, ma'am.
an issue.
Yes, ma'am.
So that is why I thought that I got confused
Yes,
initially.
I'll try to, my lord.
Initially,
Yes, madam.
but slowly or steadily,
Yes, madam.
I am
In fact, this matter I argued before your
thinking
lordship.
of reaching a destination.
Yes, madam.
This way or that way.
This way or that. My
Initially,
anxiety
I
is
was
that
confused.
if the writ petition is allowed, madam, it will have severe ramification in the subsequent claims of the state, madam.
So,
This is an isolated
some
case, ma'am.
claim you get the thing by limitation. You can raise a plea of limitation.
True.
It
True.
is concluded. After concluded thing, you cannot raise. All those
True.
things you think of. If suppose the writ petition is allowed.
Got it, madam.
If the writ petition is dismissed, there is no issue.
There is no issue. I'll try to pursue, madam. Let's
Then not before vacation.
let me.
Because I'll be out next week. And last
first
week,
time, I'm also not been in Guwahati, madam. Let it be after reopening, madam.
then I'll put it in your mouth.
Yes, madam. I will kindly keep it as part heard, madam.
Mr. P.N. Goswami, Learned Additional Advocate General. Assam, is state by Mr. D. Gugul, Learned Standing Council Forest Department.
No, my lord, he is actually it's a matter pertaining to my irrigation, sorry, water resources.
Okay, okay.
He's with me, my lord. Not
It's
correct.
stated by Mr. D. Gugul and Council. Has submitted that it appears that there are many contentious issues which are to be addressed, and he needs some time to address those issues, address on these issues, those stuff. Maybe 20 January.
Perfect, man. 20 January.
Mr.
H.S. Bora.
H.S. Vora Learned Counsel for the petitioner is present and has submitted that he has no objection to the prayer made on behalf of the state person as sought for by Mr. Goswami and as agreed to by Mr. Bora, list the case on 20/01/2026.
I'm deeply opposed.
as part heard.
Deeply opposed.
Parhat matter, item 2.
Start from afresh, but bit slowly. I am not very.
Lordship, I got time to research some more
Ah.
elements.
Not very that conversion with this
Lordship,
subject.
we'll start from the issue. What was the issue? Lordship, the
Okay,
financial
take
year.
me to the document first.
Lordships,
Take me to the document
Document.
first,
Lordships,
right?
Lordship,
Thereafter, I can.
Lordships. The issue, Lordship, documents I will take just to recapitulate, Lordship. The issue was regarding the definition of month as
No, first you take the facts to the facts,
to the fact, Lordships.
to the documents.
To the document. Lordships, a show cause notice at page number 49,
14.
annexure 3 was issued to the petitioner on 29th of November 2024. Wherein certain demand of tax has been made for the period April 20 to March 21, financial year 2021, issued under section 73 of the CGST and Assam GST Act, Lordships. Lordship, we had come to your Lordships directly basis this show cause, alleging that this show cause notice is without jurisdiction as the time limit to issue such show cause under section 73(2) has already elapsed. And therefore,
Any order was passed.
Lordship, subsequently, when the writ was pending, the department has passed an order confirming the demand, which was ultimately stayed by your Lordships because during the pendency of the writ petition that was done. We had handed over the copy of DRC 07 also, Lordships. That was. Lordships.
Yes, where is Mr. Gogoi?
He'll be here very soon, my lord. He's
Okay.
arguing a matter in court number 7, my
On
lord.
28th of February 2025, Lordships, the demand order came to be passed,
Okay.
which your Lordships had stayed the proceedings basis because the writ was pending and the issue was under active
In
consideration.
any of the order, it has been referred to.
Lordships, it has been, Lordships.
Where is that?
Lordships, I'm just taking on.
27 to. Will that be given?
Order dated
Yes, yes.
3rd of
Yes, yes. I've got it.
Lordships. Order dated 3rd of April. That this order will not be given effect to because of the pendency.
Hmm.
Now, Lordships, the issue that is before your Lordships is regarding the interpretation of month as given under section 73. So I request my lords to take section 73 for the time being
CST.
of the CGST Act. And I have extracted that in my petition, but Lordships.
Let us have the book.
Lordships.
পুরনো পুরনো awesome. Yes.
Section 73, my lordships. Section 73, lordships, states determination of tax pertaining to the period up to financial year 23-24 not paid or short paid or erroneously refunded or ITC wrongly availed or utilized by any reason for other than fraud or willful misstatement or suppression. Lordship, section 73(1) I will place, where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where input tax credit has been wrongly availed or utilized for any reason.
What is
other
the
than-
allegation against you?
Lordship, my allegation against me is input tax credit, irregular availment of certain input tax credit.
Which out of 5, which one is?
Lordships,
Out of the 5,
out of the 5.
tax not paid, short
Lordship,
paid.
input tax credit has been wrongly availed or utilized.
Okay.
Input tax credit, ITC. There is both the components, Lordship, output, input, both is there in my case, both. Some portion is input tax, some is output short paid as per the allegations. he shall serve notice on the person chargeable with tax which has not been so paid or which has not been so short paid or to whom the refund has been erroneously made or who has wrongly availed or utilized input tax credit, requiring him to show cause as to why he should not pay the amount specified in the notice along with interest payable under section 50 and a penalty leviable under provisions of this act or rules made thereunder. Now, 73(2), which is important in our case, the proper officer shall issue notice under subsection 1 at least 3 months prior to the time limit specified in subsection 10 for issuance of order. So, Lordship, 73(2) is linked with the date of passing of demand order. Lordship, in that case, Lordship, I will take your Lordships to kind 73(10). The proper officer shall issue an order under subsection 9 within 3 years from the due date of furnishing of annual return for the financial year to which the tax not paid, short paid, input tax credit wrongly availed or utilized relates to, or within 3 years from the date of erroneous refund. Lordship, 73(10) says the order has to be issued within 3 years from the date of annual return. Lordship, annual return is specified under section 44. Lordship, they kindly take section 44 for this.
Yes.
44 annual return, subsection 1. Every registered person other than an input service distributor, a person paying tax under section 51 or 52, a casual taxable person, and a non-resident taxable person shall furnish an annual return which may include a self-certified reconciliation statement reconciling the value of supplies declared in the return furnished for the financial year with the audited annual financial statement for every financial year electronically within such time and in such manner as may be prescribed. Lordship, this prescription is given in Rule 80. Rule 80 of the CGST rules, Lordship, may kindly take this.
Yes.
Lordship, Rule 80 annual return. Every registered person other than those referred to in second provision to section 44, an input service distributor, a person paying tax under 51, 52, a casual taxable person, and a non-resident taxable person shall furnish an annual return for every financial year as specified under section 44 electronically in Form GSTR 9 on or before 31st day of December following the end of such financial year through the common portal either directly or through facilitation center. So, Lordship, the due date to furnish the annual return is 31st December following year. So, Lordship, our period is 2021.
1 minute.
Lordship.
Huh.
So, financial year 2021 is the period, Lordships, in this petition. So, the original due date under section 44 to file the annual return was 31st December 2021.
December
2021.
Yes.
Now, Lordship, kindly takes sub rule 1A just after rule 80. Notwithstanding anything contained in sub rule 1 for financial year 2021, the said annual return shall be furnished on or before 28th day of February 2022. So, Lordship, for 2021, this was extended up to 28th of February 2022. There was a 2 months extension given by the statute and a rule 80 sub rule 1A was introduced.
Yes.
So, Lordships, we have now the due date of filing annual return with us for 2021, which is 28th of February 2022. Now, Lordships, again, kindly I can take your Lordship to 7310 now.
Yes.
Lordship, 7310 says the proper officer shall issue an order under subsection 9 within 3 years from the due date of furnishing of annual return. So my case annual return was 28th of February 2022. 3 years would be 28th of February 2025. And Lordship, the order that I had handed over to your Lords, Lordship, the department had passed the demand order on the last day itself. Which your Lordships had seen, it is dated 28th of February 2025 because as per 7310 read with 44 and Rule 80 sub Rule 1A, the last day to pass demand order was 28th of February 2025. Now, Lordship, in this context, we have to now see what is the due date to issue show cause notice as per 73.2. 73.2, if I place Lordships again.
Yes.
The proper officer shall issue the notice under subsection 1 at least 3 months prior to the time limit specified under subsection 10 for issuance of order. So the Lordship, the legislature uses the word 3 months prior. Lordship, months is not defined under CGST Act anywhere. So we have to take the reference to the Gender Clause Act section 3 subsection 35, wherein it has been clarified a month would be in a British calendar month.
Which clause?
335, Lordship. I have extracted that in the petition, Lordships.
Section 333.
Lordships.
Yes.
It is extracted at page 14, para number 9 of the petition also.
Then it was a second.
So, Lordships, in the given case, the last day to pass order was 28th of February 2025.
When the notice was issued?
Notice was issued on 29th of November 2024.
Show cause. Yes.
Show cause notice, Lordship, page 49, Annexure 3, 29th of November 2024.
Well, 2024.
24, Lordships. So, Lordship, now we come to the point, Lordships, on the definition, the month is not defined under the CGST Act or the Assam GST Act. So, when we go to the General Clause Act, Lordship, the General Clause Act defines month to be referred as a British calendar month. 335, Lordship, that is extracted at page 14 of the petition. Month shall be reckoned. Month shall mean a month reckoned according to the British calendar. No, Lordship, I place judgment, Lordship, before that, Lordship. So 28th of February 2025, 3 months, minimum 3 months. The statute uses the word at least 3 months prior. And there is why the statute, Lordship, says this, because in this 3 months, I have to, when I have put to a show cause, I have to be given time to reply to the show cause. And under section 75, I can also seek personal hearing to attend the show cause. And the department has to give me, I can seek for minimum 3 adjournments also to go and to attend a personal hearing. So therefore the statute says at least 3 months time has to be there between the date of issuance of show cause and passing of order. So if I take 28th of February 2025 being the last day to pass the order, 3 months would go back to 28th of November 2024. Because the jurisprudence of the definition of month, as has been held in various case laws, which I will place before your Lords, it was the month is to be reckoned as the same day of the corresponding month or the previous month.
They're the corresponding month. That is why I am asking the question.
Lordships.
Corresponding month, it is laid down in the statute.
Lordships.
Where is the
backward calculation?
Yes.
Lordships. For that, Lordship, I did some research yesterday night and I've come up with
that is what
Lordships. May kindly just take this judgment. I have brought 3. The GST judgments, the Lordship, I have already placed. Shall I take your Lordship to those judgments first?
So Telangana simply.
Telangana.
Or you have shown me Telangana.
Lordships, Telangana
without any region.
Lordship, Andhra Pradesh.
That British judgment, then simply say in
Lordship,
time.
Lordship.
That I am not very,
Lordship, Lordship, let us take this judgment. It's a old judgment of 2018 by the Honorable MP High Court in the context of definition of month. Lordship, may I kindly take the issue which was framed in para number 2 and 3.
all these have been laid down. I am on that point.
Lordship, this judgment,
Which
Lordship, the Lordship,
First,
that
you
is,
take me to the paragraph.
Lordship, kindly takes para 12 onwards. They have extracted the
No, no,
Halsbury
this
laws of
BP
England.
Salma I have seen.
Lordship, Halsbury law of England.
Halsbury also seen.
Lordship, that clarifies the position.
Let us see.
Lordship, Halsbury, para 13. Page number, internal page 3, para 13, Lordships. May I place this, Lordship?
Hmm.
In Halsbury Laws of England, 4th edition, para 211, the explanation is given in regard to meaning of calendar month running from arbitrary date as under. Calendar month running from arbitrary date. When the period prescribed is a calendar month running from any arbitrary date, the period expires upon day in the succeeding month corresponding to the date upon which the period starts. Save that if the period starts at the end of a calendar month which contains more days than the next succeeding month, the period expires at the end of that succeeding month. Now let's shift next page. If a period of one calendar month includes the last day of February, there must be 29 or 28 days according as the year is not or is not a leap year. The aforesaid explanation makes it clear that if the period of 1 month commences from a date subsequent to the first day of the month,
If the
then the
period-
calendar month will be complete
If the-
upon the day.
1 minute, 1 minute.
Lordship. This has brought down the position, Lordship, that a month, when a statute refers to the general clause, a month can have 29 days also, 30 days also, and 31 days also, depending upon when the period starts. Lordship, may I place this para 14?
Hmm.
The aforesaid explanation makes it clear that if the period of 1 month commences from the date subsequent to the first day of the month,
If the 1 month period starts from 28th January.
period of 1 month commences from a date subsequent to the first day of the month. Means it is, say, second of the month.
If the 1 month period starts on 28th of February,
Starts on 20, then it would be over on 19th of March. They are taking 1 day less. In fact, in my case, I am still sticking to the same
this
day.
is against,
This is again in favor of him.
this is not.
Lordship, I will place, Lordship. Let me place this. Lordship, let me place this what finally it has been.
No way, this is not, no way. It is completely against Saket.
Lordship, I will place, Lordship, what this says. Lordship, kindly judge this paragraph. For example, if 1 month period starts on 20th February, then it would be over on 19th March. Similarly, if it starts on 20th March, the 1 month period will be over on 19th April. Hence, the period of 1 month will have 28, 29, 31 or 30 days, depending upon the month, that is February, March, April, in which the period had commenced. I am only on this line.
Third line,
I'm only on
last
this
line
line.
is okay.
Only
Last line is okay,
Only on that.
but I am not
Lordship,
convinced.
I am not placing that line because, Lordship, that would in fact mean that it should expire on 27th in the present case. But Lordship, I am still sticking to 28th.
Right.
I'm
No,
speaking-
this paragraph 14,
Lordships, the last line.
last line
And that is the crux, Lordship,
is
that
okay.
calendar
Last line.
month can have, depending upon from where it starts, it can have a various days because when the statute chooses month, then
All
it has
throughout, I don't know, all throughout, it has been explained. Suppose, because taking into account the month
Lordship,
and plus other explanation, the general clauses.
Lordship,
If it is period of 1 month is to be counted from, say, this example,
Lordship,
20th of February,
Lordships,
right?
20th of March.
It is 20th of March. This logic is,
Lordship, I am absolutely on that
this
with
is
your
to
Lordship.
be,
I am not arguing on that point.
this is to be striked off. This is irrelevant.
How the last
This line.
line, Lordships? Last line is something which was
Okay.
I am trying to emphasize, Lordship, because that brings down the crux of the month, that when the statute uses the word month, it can have multiple days. It can have 28, 29, 31 or 30. So when the statute had the
That is a fortuitous thing. Suppose it is from February,
Lorships,
say 15th of February,
Lorships,
it will end on 15th of March,
Lordship.
1 month.
Lorships,
That may have lesser days.
lesser days.
Then, if the period starts from 15th of March
Up
to
15th
15th of April,
I go down. I
right?
go down to that.
That
And
concept is clear.
that
That depends on the facts of the case and
that-
situation.
why I'm trying to place that, Lordship, because if that concept, if we are on that page, Lordship, then 28th of February 25.
Basically, Mr. Kanodia, I am onto it. These all are going forward.
Forward, Lordship.
No,
Lordship, I understand your Lordship, what is falling from Lord's last occasion also.
Huh.
Lordship, I researched yesterday night also. I got 3 judgments. I researched with the
This
phrases.
is okay, sir. Last line is okay. The last line is conformity with all the
Lordship, I-
judicial precedents.
Lordship, placing just 2 more.
If this is a paragraph 14, you are placing.
Yes. Paragraph 14, last line. Halsbury, paragraph 13, the Halsbury law, and
This is okay. This is okay. Last line.
Lordship, 2
So
more
this is
judgments.
last line you are placing.
Lordships.
Other I am striking off.
Lordships. Lordship, in next Lordships, may kindly take the
Though
judgment.
small, but it is still,
Lordship, it is. That is why.
still ringing in my mind.
Lordship, may kindly take the judgment of Honorable Odisha High Court.
Orissa.
It's a 1961 judgment.
Just you tell me first para so that I
Lordships.
can-
Para number, Lordships. Lordship, in fact, sorry, Lordship, the Madras High Court kindly takes first. Para number 8.
Madras.
This is in regard to Income Tax Act, Lordships.
Yes, para, you say.
Para 8, Lordships. 8, 9, 10.
Eight.
8, Lordship. Lordship, if Lordship want to see the fact, then para 5 I will place. What was the factual case in this particular? Para 5, Lordships. Before proceeding further, we can make one thing clear.
Which one? Which para?
Para 5, Lordships. For the fact.
Okay, okay. Huh.
Before proceeding further, we can make one thing clear. On the finding of the tribunal that the income tax officer had given time to the SSC to file return of income till January 15, 1962, the default commenced only on January 16, 1962. But on February 15, 1962, the SSC had filed the return. If the argument of department is to be accepted that SSC filed the return after the expiry of 30 days, that is on the 31st day, and therefore there had been a month's default. On the other hand, it is if the argument of the SSC is to be accepted, the SSC had filed the return on the last day of the month of default, and consequently there had not been a month's default so as to calculate penalty at a particular percentage of the tax for a month. Which of these contention is correct is the question that is now being considered. This was the facts, Lordship. Now, Lordship, para 6, they say that month is to be reckoned as per the General Clause Act. It is the same thing given, Lordship. Lordship may kindly take para 8 now. How a month is to be reckoned has been subject matter of consideration by courts. According to Words and Phrases, Permanent Edition West Publishing Company, the term month, whether employed in modern statute or contracts and not appearing to have used in a different sense, denotes a period terminating with the day of the succeeding month, numerically corresponding to the day of the beginning, less 1. In fact,
Same thing, which
less 1
you
because
have to tie it. You have to tie it against it.
Lordship, less 1 would mean a better case for me, that because in that case it would expire on 27 November. In my case, facts, if I rely on this dictionary also, Lordship, this would mean less 1 would mean 28th of February 2025, 3.
No, there is absolutely no doubt to this proposition.
But Lordship, I'm trying to identify, Lordship. If there be no corresponding day of the succeeding month, it terminates with the last day thereof. So, Lordship, I am trying to say, if in my case, 28th February was the last day to pass order, And there was a corresponding day, 3 months or prior to that, there was a corresponding day in the statute, which was 28th of November.
So, though I'm still asking the question,
Lorships.
if you go by this words and phrases, denotes a period
Lorships.
terminating with the day of the succeeding month, numerically corresponding to the day of its beginning,
Lorships.
right? So, every concept, the 30 rule 3,
Section 3,
no,
subsection
not section
35.
3.
Month shall mean a month reckoned according to the British calendar.
You have to read rule 9 also,
Lorships. Lorships.
right? This is conformity with rule 9.
Lorships.
Rule 9 of the general clause.
General clause.
It also says, if any central act made after this, it shall be sufficient for the purpose of excluding that is counting.
Counting.
That is counting. Month is there.
Lorships. Then how to calculate?
How to calculate?
Lorships.
That has been laid down in numerous decisions.
Settled.
Numerous decisions.
That is settled. Lorships.
Right.
On that,
But the
acknowledge.
concept is, but concept inherent in it is that first of the day is to be excluded,
Lorships.
and meaning thereby for 1 month the corresponding date
Correspond.
in the succeeding month.
In the succeeding.
That is the consistent concept,
Lorships.
right?
Lorships.
Now here is a
Backward. Going back.
going back.
So Lordship, if we.
So when a statute, suppose my question is,
Lordship.
when a statute and all long line of precedents, and that right from that Dodor Dittel,
Lorships.
that corresponding day in a month,
Lorships.
it may happen that 3 months or 3 months period may have 89 days, 90 days, 91 days, or 92 days, whatever. Similarly, depending on the situation, the month, that legal month, may contain 29 days, 30 days, or 31 days, depending on the
sequence.
month on which
It starts.
starts.
Lordships.
Right? This is the concept.
This is the concept.
That is settled.
That is why I am trying to settle this also, Lordships, by stating that when the corresponding date is to be taken, in my case, if I don't go by
So,
any judgments,
meaning thereby, every thing depends on two things: starting point, end point.
Lordships,
Now here,
we have the end
if you
point.
go, we have the end point.
We have the end.
End point. Now, how the other way around?
Suppose we had the show.
Because the concept, statutory interpretation is
corresponding date
corresponding day
of
in
the
the
subsequent month.
so like 2 months or 3 months also. Here it is a case of 3 months.
Lordships.
Now, if we feel
Reverse it.
see the logic, if we take
Lordships.
28 November 2024
Lordships.
is the starting point,
Lordships.
that can happen.
Lordships. That can happen.
Then it fits the bill,
Lordships.
right?
Lordships.
Secondly, that is according to section 9 and
Rule 9 and
235.
3, Lordships.
But whether that is acceptable or not,
That's where my lords will decide.
that is one issue.
Lordship, just
That is one issue.
Lordships.
And secondly, suppose, hypothetically, if we take 30th November 2024 also,
Lordships.
because of ending it in February, 3 months will be
28th of February only.
28th of February only,
Because last date of that,
2025.
if that date is not available,
Because-
the last day of that one.
Because otherwise, earlier it was prior to amendment, it was 31st December.
31st
So concept is always there at the end day,
Lordships,
right?
Lordships.
The question is whether this concept can be reversed from 28th February 2025. So taking back,
3 months.
because to calculate, you have to deduct 1 day. If that, if you want to apply this concept,
Lordships,
right?
Lordships,
If you want to apply this concept,
Lordships,
this concept which is you are insisting,
Lordships,
28th of February is to be
deducted,
deducted,
Lordships.
right? Then if it goes back,
Then it goes back to 27 November. Because if one day, 28th February is the last day, I cannot go beyond
no,
and start it by
then it
1st
is,
March.
then it is corresponding day.
Lordship,
See, if you apply this logic,
Lordships,
that going forward,
Lordship, I cannot, Lordship, I will,
going forward is same as going backward,
Lordships,
right? Then if 28th February
Lordships,
2025
Lordships,
is to be taken as the starting, starting point,
Lordships,
then 3 months will be March, April, May.
May.
28 May.
Lordships,
Now, if you apply the same logic, going back 28 November 2024,
Lordships,
right?
Lordships.
So it gives rise to different situations. If you apply this logic going backward, then 28 February, corresponding day will be 28 November. So maybe my questions are wrong.
No, Lordships, Lordships. I'm trying to understand, Lordships.
Because every judgment
Lordships,
is going forward,
Lordships,
not going backward.
Backwards.
Except Telangana.
Lordships, I had in fact given a compilation.
Except Telangana. Telangana simply says none. It is
Andhra Pradesh, Lordships.
Andhra Pradesh.
It is Andhra-
Andhra Pradesh. Done.
Andhra Pradesh,
Simply.
they say they give that extract and they say no, 28th. it
Though
will
then
be-
little or what? Then is this.
That is what has been done, Lordship. That has been followed by Telangana, Bombay.
Whatever.
Lordship, that
But
is,
I am not still.
so, Lordships, in my case, Lordships, I would say,
Okay, 8, then 9, what paragraph? Of this
Lordship,
judgment, of this Madras
in
judgment.
this
Tell me.
particular Lordship, 8, 9.
9, let us see.
9
Same.
is also
Very same.
same.
Same
Same. And then Lordship kindly takes in para 15, they have again quoted the Halsbury law. Para 15, Lordships. And para 17, I will place, Lordships. Para 82, they have quoted of Halsbury. In that one was para 211. In the other judgment, Lordship, of the Madhya Pradesh, it was para 211 of Halsbury. Here it is para 82 of the Halsbury law of England.
Because it is, I think, 3rd edition.
Yeah, it is 3rd edition, Lordship. That was
Earlier was different.
earlier was Lordship's different edition.
See.
That was 4th edition.
Ah.
That was.
So there may be change. But words are same?
What's
No,
up,
different.
Lordship, here it says in para number Halsbury law of England gives the variant meaning of the word month. That paragraph states the term month is used in several senses. It may mean one of a 12 unequal parts into which calendar year is divided. It may mean the period which beginning on any day of a calendar month other than the first and on the next day before the corresponding day of the next month, or it may denote a lunar month. That is, it's a different meaning. Lordship, para 17, the conclusion adopted by the court. As so far as the present case is concerned, we have pointed out already the default commenced on 15 January 62. Consequently, 1 month of default would have completed on February 15, 1962. But on February 15 itself, the SSC had filed the return. Consequently, the default had not lasted for a month as provided under 271(1)(a, dealt with 335 so as to attract penalty. Because they said a last day you have complied, so therefore default not occurred, therefore penalty not liable. So in my case, had the show cause been issued on 28th, I would have not come before your lords. I would have replied to the show cause. Now, lordships, last one judgment I had placed, lordships, of the Odisha High Court. Lordship, kindly takes para 4 again, Halesbury second edition here. So third edition, fourth edition, this is the second edition.
Para 4.
Para 4 I'll place, lordships.
So I'll use fifth edition.
Lordships, as whatever I could have, lordships, a legal question. Yesterday night, whatever I thought I can again
No.
bring something, so I have got this. Otherwise, I would have
I'm
come.
finding it a bit interesting. That is why
Lordships,
I
lordships, in Halesbury's Law of England, second
like to hear
edition,
you.
volume 17, para 176, the principle applicable to the case of this type has been laid down thus. When the period prescribed is a calendar month running from any arbitrary date and not coinciding with any particular month in the calendar, the period cannot exceed in the length the number of days in the month in which it starts. And when the second of the 2 months on in which the period falls is a month containing fewer days than those contained in the first month, the number of days in that period may be less than those of the first one. This is our case. February, less numbers. Now, next paragraph. In note M at the foot of the same page, it is further stated that the period of month which begins on 28th or any later day in January must in the ordinary year terminate on February 28th. See also the decision cited in note N in the same page. Hence, in agreement with the learned single judge, would hold that the notice to quit was a valid.
In context of what?
This is in context of notice, notice of eviction.
No. Act. Because note must have appeared somewhere.
Lordship, it was a single judge judgment.
No, note, this note.
Lordship, they are referring to the note in the dictionary. They are referring to the note in note M at the foot of the same page. Lordship, page 176 they have referred. In paragraph 4, they are referring to that, lordships.
Period of month.
Lordship, may kindly take page para 3. The facts would be clear in that case. In what factual sense it was,
I have understood.
lordships. Only this page, lordship. Other pages of this are not relevant. But I have to bring the whole judgment. That is it.
But same thing. Counting.
The counting, lordships, corresponding date if available.
We're counting there are many Supreme Court decisions counting on the counting.
Lordships.
Same thing, corresponding in a month.
Lordship. And lordship, then Andhra Pradesh, your lordship had seen it is
Andhra Pradesh I have seen and I have read this your
Dodge versus Walker.
I have read it many times.
Lordship, to my lordship, I am not able to interview lords can I have
Could not
lordship.
decipher.
If my lords cannot, then
Could not decipher
there is
it.
no point of us going into that, at least lordships.
Where is that paragraph?
Lordships, in Andhra
that-
Pradesh High Court judgment, lordships.
No. Andhra Pradesh judgment. Yes.
Andhra Pradesh judgment I have given separately.
It
Page
is there,
number-
it is there.
Page number 4, internal page 4, para 4. Thus, they
This
extracted
Dodds and Walker.
para 7, lordships. Page number 6, para 7.
Dodds and Walker.
Lordships.
Then I read the entire judgment. I read the entire judgment. It is a tenant issue.
Different issue.
Then I read and I got more confused.
Lordships, that para is extracted at page number 7,
Seven, yes.
para 9.
Huh.
The Honorable Supreme Court, while considering the issue and after noticing that Section 335 of the General Clause Act defines a month as meaning a month reckoned as a British calendar, has also noted the judgment of the House of Lords in Dodds versus Walker. The House of Lords, while considering the period with which the tenant can approach the court under the Landlord and Tenant Act, had observed as follows. Shall
Go
I please-
slowly. This is
Yes, I'll press
read slowly.
slowly. This simple general rule with Cogburn CJ in Freeman versus Red 1863 4 B&S 174 184 described as being in accordance with common usage and with the sense of mankind works perfectly well without need for any modification so long as there is in the month in which the notice expires a day which bears the same number as the day of the month on which the notice was given. So it says,
Suppose if you read this, there is, because endpoint is there. There is in a month in which the notice expires a day which bears
the same
day,
the same number
same number,
as the day of the month on which the notice was given. It's 28, 28.
28,
And
28. It fits.
It means therefore
It fits.
it fits. That is
It
why.
fits the case of the department.
No, in my case, they have issued the show cause on 29th. I am before your lords that it has to be issued within 28.
29 is after 28, sir.
So Lordship, my case is last day was 28.
29 is after 28.
Yes, so last day as
If this line is interpreted, then it is 29.
No,
So,
Lordship, how Lordship it says
since there is another concept, if you give it on a day and in the corresponding month, there is no similar day,
the last day of that month.
then it is last day.
Last day.
So if you give the notice, suppose this concept,
Lordship.
if you give the notice on 28, 29, 30 of November,
Lordship.
it does not make any
Difference.
Lordship. Because everything will end on
28th of February 2025. I brought on to the Lordship. Now, therefore, why minimum 3 months? 73(2) uses the word Lordship minimum 3. That minimum 3.
Not minimum 3, at
Actually,
least.
Lordship, I apologize. At least 3 months. So, in that context, if I read this here, it says my end date is defined as 28th of February 25 and 3 months going backwards. If there's the same day available, it would expire on 28th November. It fits my case also, Lordship.
Read further.
Lordship. Such was the instant case, and such will be every other case except for notices given on 31st of a 31-day month and expiring in a 30-day month or in February, and notices expiring in February and given on the 30th or the 29th except in leap year of
This
any-
part, please read again.
Lordships. Such was the
No, after the word except.
except for notices given on the 31st of a 31-day month and expiring in a 30-day month or in February.
Stop.
It says-
Because it says this 73, section 73 says two things. Giving of a notice is must.
Lordships.
An order has to be passed. That notice must be at least 3 months
Prior to the date of passing order.
passing order.
Lordships.
We know the passing order, date of passing order.
Lordships.
Thereafter, everything goes.
And after
28 February, it has been fixed.
yes.
And they have brought it from, by the notification, from 31st December to 28th February by amendment.
Lordships.
Right.
Lordships.
Now, if we see from that angle,
Lordships.
notices given in a 30th day, 31st November is 30,
Yes.
right?
Lordships.
30th day of a 30-day month and expiring in a 30-day month or in February,
Lordships. Last day.
last day,
Last.
in February, then this is the situation here.
No, it is not here, Lordships. Most humbly, Lordship, because the statute fixes the outer limit and statute says, okay, I am giving you the outer limit, but you have to comply with 75 also. Lordship, kindly take 75 for once.
70?
75. General provisions for relating to tax determination. 75 of CGST. GST, Lordships. $75 by Lordships was there.
Yes.
Which is 75, 4 and 5, 74, 5, 75, 5. The proper officer shall, if sufficient cause is shown by the person chargeable with tax grant time to the said person and adjourn the hearing for reasons to be recorded in writing, provided no adjournment shall be granted for more than 3 times to a person during the proceedings. Now, Lordship, this period which is there 3 months, all these proceedings, adjournments, and my reply has to be considered and done in this 3 months only. That is why for non-fraud cases, it is 3 months. For fraud cases, it is 6 months.
Yes. Any other judgment?
Lordship,
Other things are simple.
Lordship, I have relied, Lordship, Andhra Pradesh I had given you lots. Then
Yes.
basis that Telangana had just, it's about a 2
Yes,
paragraph. Telangana judgment.
Telangana, Andhra Pradesh is there.
Andhra Pradesh I had submitted, Lordships.
Then you have submitted this Odisha.
No,
Then-
Odisha today, Lordship, that is on different context. That is on the month. I'm saying for the GST Act only. I had given a compilation, Lordship.
Yes, it is there. First of the Andhra Pradesh is on GST.
Andhra Pradesh is on GST.
Hmm.
Then, Lordship, there was a Patna High Court.
Patna.
The para 30, page 34.
Para 30.
It was in different context of,
Para 30.
it was in the context of,
What is the running page?
Lordship, running page 34. The page numbering is there, Lordships.
Yes, is that
Page,
it?
page 34, Lordships.
34. Which paragraph?
Para 30, Lordships. From the judgments of the Honorable Supreme Court quoted above, we have no doubt that in the present case, 3 months period from the receipt of the order of the authority expired on 27/3/24. The appellant could have preferred the appeal within a further period of 27/4/24, showing sufficient cause to the appellate authority to satisfy that the appellant was prevented by sufficient cause from presenting the appeal within the forward 1 month. In this case, the appeal was preferred on 26/4. Therefore, the appellant was required to consider the cause. Here it was regarding the computation of 1 month under section 107 of the CGST Act. That in Lordship, in 107 is the provision for appeals. The time period to file appeal is 3 months with a condemnation of 1 month. So that 1 month they have interpreted, and here also, Lordships, various judgments.
This concept is has been clearly explained in Himachal Tech
Himachal,
Engineers.
Lordships. Himachal. I bow down to that. That is what.
That is explained clearly.
Clearly,
Months and days.
Lordships. And
There it was period of condemnation delay was 30
Days.
days.
30 days. So that has to be calculated.
That has to be calculated.
That is
For month
Himachal
is
took no
month
less.
is corresponding day.
Lordships. It rests
If
down. It rests
There
down
is
the
no
every dispute.
corresponding day than any previous day.
Lordships.
Anything?
Lordship, these are the 2 major judgments. Then Allahabad in the page 36 was in context of Finance Act.
What is the concept there?
Lordship, here it was
Running
regarding
page,
delay,
running-
90 days or 3 months.
Running page?
Lordship, running page would be page 37, para 6 and 7.
37, para 6.
And last, Lordship, page 39 is the Himachal Techno, which my Lord says already seen.
Para 7.
Para, in page 37, Lordship,
37, para 6.
para 6 and 7. Here
7.
it was regarding Finance Act, 90 days or 3 months.
That section 335 General Process Act.
Lordships.
Then Tamal Lahiri.
And then para 8 is the conclusion. In the present case, the order of adjudication, it is admitted, was received on 8th of October. The period of 3 months would come to an end on 8th of January 2020.
Yes. Then
Lordship is Himachal Techno.
Himachal.
Today, Lordship, whatever I had given was regarding different interpretation for the dictionary. Nothing more on that, Lordship. My only concluding remarks would be, Lordships, in the case when we are calculating forward and there is settled jurisprudence that if the same date is available in the subsequent month, then same logic should be applied while going backwards. In my humble.
And that is what
That is why my only
Which-
conclusion submission.
question is acceptance of the submission.
That's Lordships will decide.
Right.
Lordships.
And it is not the end of the thing, it should be settled.
Lordship, it has.
It is grey.
But Lordship,
No, that-
what I
because-
researched yesterday,
because on Andhra Pradesh,
Lordship, what has happened from Andhra Pradesh, no SLP has been preferred. Till yesterday, I had verified from my local councils also there. The CGST department there has not preferred any SLP. From Andhra Pradesh and Telangana, both Lordships.
I don't know from this. Let's go this. Yeah, they put this.
And also, Lordship, 73(2) uses the word shall. Shall at least 3 months prior. So any interpretation of shall would also come into picture that minimum 3 months. This personal hearing point was dealt by the Andhra Pradesh High Court, Lordships.
no,
That
those are not required.
Lordships.
Let us hear Mr. Gogoi.
Lordships.
My lord, so far as my lord, the arguments advanced. My lord, I have no counter judgment to give, my lord, to show that, my lord, in the reverse calculation, my lord, 29 or 30 will be the last date. But my lord, if my learned friends, my lord, takes the plea that person for non giving him the opportunity of personal hearing.
No, those are
then, my
not
lord,
the
the
issue.
entire
We are
issue
not,
goes-
we are,
No, I am not on that.
we are not.
Not at all on that.
We are not,
Yes,
we
then
are
this
trying to
entire
find,
exercise is not
we
necessary.
are not going into the
Yes.
other issues. We are only sticking on 28
In reverse-
November
reverse.
2024 and 28 February
On
2024.
the reverse calculation, what will be the end date?
Because what is the opposite of, what is the meaning of corresponding?
Meaning of corresponding. Corresponding would mean the same day. I'll just search. Lordship, it means, if it's an adjective, it means analogous or equivalent in character, form or function, comparable. As per Cambridge Dictionary, Lordship, it is similar to, connected with or caused by something else.
Yes, anything?
I leave it to your lord. So far as the case is concerned, my lord,
Because all judgments were going forward.
yes.
No dispute.
Only, my lord, one or two.
All the judgments.
All. And what other courts have decided also, basis that only going backward.
Going back, simply,
Same.
even
In simpliciter form.
I am reading this Andhra Pradesh judgment also.
Lordships.
Uh,
In simpliciter form, they have relied on that and stated it is backward also same too.
But there could be three situations also. If we take this period, 3 months, has to be there at least. Then any day, by first concept, corresponding day concept, if you take 28th November 2024 as the starting point, it fulfills the criteria. If we take 29, it also fulfills the criteria.
Going forward, it fulfills.
And 38
it
also fulfills,
Lordships.
right? But going back, it does
only
not
has got
fulfill.
it. In fact, the judgments of MP, which of course, Lordship, that line has Lordship has struck down. I am okay with that.
No,
But
no, no. Which one? Oh, that
The
one.
MP,
Oh, no,
that,
no.
that one,
That is- no,
Lordship,
no.
that is why I am not placing that. But in fact, that would have been.
I cannot sail with that.
No, I'm not on that. Therefore, I told Lordship struck down that, but the last line, the interpretation that was
I have cut it.
Lordship,
Last line, yes, hence.
Lordship. That is what some research I could have done, Lordship, because of the extended time which I got.
But Mr. Gogoi,
My lord.
I could not get it, what you have written in your note.
No matter that part, now my lord, it will be calendar month. But I had.
Because I could not get it.
started
I
calculating by
tried to
days.
read it.
No, I calculated it by taking it as days, my lord, 28 days, 30. That will not be there.
Because I
because it has
tried,
been-
and I could
Yes.
not understand.
That has been clarified, my lord, in the.
Heard Mr. A. Kanodia, learned counsel for the petitioner, and Mr. B. Goy, learned as a standing counsel, advocate general, additional advocate general, Assam, for all the respondents. Arguments are arguments concluded. Judgment is reserved.
Lordship, the interim order was continuing.
It will continue.
Himachal Pradesh दिखाया ना आपने सब Himachal Pradesh. In that Himachal Pradesh case, my lord, Himachal versus Techno. There, my lord, again, my lord, it will be the appropriate subsequent month. Irrespective of whether some months are longer than so. Ultimately, my lord, that if 28 days is there in the month and period.
After Mr. Kanodia put me in a fix, I also tried to find out.
My lord.
Anything is there to support that,
Lordship.
anything going back.
Lordship.
Going back, basically, if there any
Yes.
concept
My
to
lord.
calculate
Of reverse
days
calculation.
by going back, I could not find.
Lordship.
That is the problem. Except that Andhra Pradesh.
Andhra Pradesh relied by Telangana and Bombay also. Bombay has given a stay relying on that.
No, interim.
Interim protection, Bombay. Telangana is final. Andhra Pradesh
What
relied
is Telangana?
Telangana. Lordship. I handed.
Sometimes small issue
Yes, my lord.
creates more problem.
This is Telangana.
No, it's a gray area, my lord. Whatever lordship decides now, my lord, by elaborating everything, my lord, that will prevail now.
No, that will be
My lord.
Subject matter of consideration for a higher forum. Where is the logic?
Lordships, the logic is given, Lordships, para number 5, page number 2.
We find that.
Logic is Cotton Corporation, Andhra Pradesh. Lordship, that is why. But here the writ was allowed. And contested it. Therefore, again, Lordship, and Bombay Lordship was interim, therefore, it was interim order relying on.
But they are 30 11. We have issued on 20.
No, but the date, corresponding date month is there.
Himachal says
My lord,
going forward.
going forward. That's.
Okay.
Grateful to you, Lordship. Much, always a pleasure, Lordship, and receive us.
Obliged.
Jadi boleh. Karen mana ki? Betul no. Have you video?
13 and 14.
Well, the section 6(1), gazette notification of alert 13 I have given, alert 12 I'm placing it. LA 12 of 24.
13 on after option.
13 also I have copy if necessary. I'm also, I'm handing over. 12 and 13 both.
Sir. Some requisition from you. In this.
My lord, can I just a small one?
On that day, full day, I have half day, full half day.
By a few seconds only. Only a few seconds. Your lordship permits me otherwise.
Then again, it will disturb my thought process. Yeah.
But my lord, they themselves, regarding their, yesterday they have said that this land is under municipal area, though not comes under its classification rule and law and acts, my lord. Here, the brochure, they have assessed against our land for compensation itself, saying that this is 1:2 means rural area. And election held in the last Panchayat election held in this area in the May 2025. And my lord, we have received a copy kindly. My lord, I'm giving also to my learned friend also, my lord. And as for section 9 of the act, DC can suamoto do it, my lord. If it is not for cultivation for 10 years, section 9 of the Declassification Act, within 60 days of the act come into force, my lord. 1:2, my lord, fraction comes only in case of rural areas. Kindly see the 26(2, my lord. They themselves mentioned 26(2, my lord, or the 13 Act, my lord. (26)(2), your lordship go to a 13 Act, your lordship will find that if this fraction 1:2 is to be in rural area, not for urban area. And election held in Panchayat, last election held also, my lord, and in the May 7.
No, if it is Mr. Paludar,
My lord,
if it is rural area,
my lord, my lord,
then it is always better for you.
my lord, 23.
Otherwise, it is up to you. If it is rural area, then it should be this multiplication factor
Yes,
should be more than 1,
my lord.
right?
Right.
You will have a better case
In case of
for
compensation, my lord.
enhancement.
In case of compensation, yes, my lord.
If it is municipal, then it will be 1,
Yes,
right?
Yes.
It will be to your detriment.
that's why
Right.
I'm saying it is rural area.
That is a matter,
Exactly.
in my considered view, to be taken up in reference. You will be getting enhanced compensation for that.
Fine.
But we are into the process. And regarding reclassification issue, whether your case as per your rule 2359 and one more, whether it has to be reclassified, ought to have been reclassified or not. That is the issue here.
My lord, and 23, 13 Act or 64 Act, my lord, these two.
And they have issued a notification. They have said that 2013 Act would apply.
Apply.
Right.
Yes,
That I will note that,
my lord.
so that in case if you go to reference, that will be helpful for you,
My lord.
right? For enhancing it. And if it is rural area, then you will get enhanced compensation.
Yes,
That
yes.
it will not be confined to multiplication factor, may not be
May not be.
1,
My,
maybe more,
my lord.
right? There are other, I have seen fine. In one case, I have seen that by a real distance, where I have seen, in Itanagar I have seen, in Itanagar last week, that the more is the area, more the area, place of, the land, place of land of acquisition is at a real distance from the urban area, then multiplication factor goes on increasing,
My lord.
right? And that has been based on some Supreme Court and Government of India concept. More it is a distance from urban area, the multiplication factor should be increased.
Yes.
That is the concept
Yes.
by Government of India.
Supreme Court judgment
That is a matter to be agitated in a different forum.
Referral court, my lord. Referral court, my lord. So, my lord, my lord, then kindly take the note 2 page I have given for you ready, my lord. Ready.
Yes, I have
It will be
kept it.
convenient for your lordship, my lord.
I have kept it.
My lord, so only this much, my lord. My prayer is that only, my lord, they ought to have been updated. Many other people's numbers are
If I miss,
entered, my lord.
if I miss,
My lord.
then you remind me,
My,
right?
hopefully not.
Like, if I miss something from your submission, then you remind me.
Hopefully not be required, my lord.
No, I don't know, because such a big file,
My lord,
right?
my lord.
Both of you have the duty to remind me
Yes, my lord.
in this writ petition. Preferred under Article 226 of the Constitution of India. 20 petitioners have joined together on the ground stating that they have a common cause of action to agitate. Post. The primary contention of the petitioners is that in the process of requisition followed by acquisition, the respondent authorities have violated the provisions of the Assam Land within bracket Requisition and Acquisition bracket close Act 1964 within bracket the Act 1964 for short, as amended. As well as the Assam Land within bracket Requisition and Acquisition rules from 1964 rules, apart from the provisions of the right to fair compensation and transparency in land acquisition from a Rehabilitation and Resettlement Act 2013 within bracket the RFCTLARR Act. Full stop. The petitioners have claimed that in the course of the requisition and acquisition process drawn up wide LA case number 12/2024 and LA case number 13/2024, comma, the respondent authorities had violated the principles of natural justice in that due notice was not served on any of the petitioners while issuing notice under Section 3 and in passing the order under Section 4 of the Act 1964. Para. From the writ petition, it can be noticed that the petition number 1 to petition number 5 are successor in interest of one late Horibilas Das and one late Horonidhar Das, who and they claim that they are the owners of a parcel of land at measuring 1 bigha, 1 katha, covered by DAG number 1299 and Pata number 488. Full stop. Petition number 6 is an owner, has claimed to be an owner of a parcel of land measuring 3 kathas, 7.5 lessa, covered by DAG number 175 and Patta number 59. Full stop. The petition number 7 to 10 are successors in interest of one late Chunu Ali, and the petition number 11 to 14 are the successors in interest of one late Chand Mohammed. Full stop. The petition number 1 is the son of one late Miajan Ali. Full stop. The petition number 7 to 15 have averred that they are the joint owners of periodic patta lands covered by DAG number 18288 and Patta number 140. And the area of land is 1 bigha, 1 katha. Full stop. The petition number 16 to 19 are the successors in interest of one Rajat Ali, whereas the petition number 20 became the owner of a plot of land by purchase. Full stop. The petition number 16 to 20 are joint owners of a parcel of land covered by DAG number 1298 and Patta number 379. Full stop. Para. It is stated that other than the petition number 6, the other petitioners, parcels of land located in village Garol and their parcels of land were brought under the purview of requisition and acquisition by the LA case number 13/2014. Full stop. The petitioner number 6 says, 6 officer apostrophe. Parcel of land is located in village Mirzapur, and the parcels of land located in village Mirzapur have been brought under the purview of acquisition and requisition and acquisition, provide LA case number 12/2024, correct? Full stop. The points, the main point agitated by the petitioners, or the main point agitated by Mr. A.K. Talukdar, learned counsel appearing for the petitioners, is that the land documents annexed to the writ petition would clearly demonstrate that the petitioners are owners of various parcels of land as indicated above. Full stop. Prior to filing of the writ petition, prior to few months filing of the writ petition, the officials from the office of the respondent number 7 and 8 paid a number of visits to the localities of the petitioner and inspected the parcels of land belonging to the petitioners. Full stop. They also took measurements of lands without disclosing the reason for such action. Full stop. The petitioners came to learn that the respondent authorities were in contemplation to upgrade and widen the existing two-lane PWD road leading to the Lokopriya Gopinath Bordoloi International Airport, LGBI for short, in the vicinity of which the parcels of land belonging to the petitioners are situated. Full stop. The petitioners subsequently came to learn that the road would be upgraded and widened from 2-lane to 6-lane. Full stop. As in a process of requisition or acquisition, as the case may be, it is mandatory on the part of the acquiring and stroke acquiring authority to serve prior notices. The petitioners apprehended that the respondent authorities were taking steps for requisition or acquisition, as the case may be, without issuing any prior notice and without serving any prior notice as mandated by the statutes, that is the 1964 Act. Full stop. Mr. Talukdar has further highlighted that the areas in village Gorol and village Mijapur, where the parcels of land of the petitioners are located, are already developed, and the parcels of land of the petitioners, though classified as agricultural land in the revenue records, the parcels of land by virtue of non-use for a number of decades have become
Agricultural.
non-agricultural land. Full stop. He has contended that he has referred to rules 23, 59, 73 and 107 of the Assam Land Records Manual to contend that Land Records Manual. It was the obligation of the revenue authorities to reclassify a petitioner's parcels of land from agriculture land to non-agricultural land. Full stop. Subpara. He has Mr. Talukdar has specifically contended that for the purpose of requisition, the authorized the authority, the requisitioning authority, that is the respondent number 7, Deputy Commissioner, was obligated to serve the notice in Form A of the 1964 rules. But the requisitioning authority did not serve the notice in the prescribed Form A upon the petitioner. First of all, he has submitted that in the counter affidavit, the requisitioning authority has taken a stand that the petitioners, when sought to be served with a notice, refused to accept them. Full stop. He has questioned the veracity of such statements. Full stop. Mr. Talukdar has further submitted that some of the petitioners, prior to initiation of the requisition and stroke or acquisition process, had submitted application for reclassification of their parcels of land from agricultural land to non-agricultural land, but those applications were deliberately not given consideration. Full stop. Next, likhebo. Subsequent to he has submitted that subsequent to filing of the writ petition, the petitioners were served with running page, Mr. Nath. Running page.
If in the first,
Notice where it is.
in the first affidavit,
First affidavit.
we have marked it as page number 118.
118. Everything is renumbered, no?
Number.
Uh,
And actually A series, my lord.
First affidavit or second affidavit?
First. This is the affidavit in opposition, other two are additional affidavit.
Petition.
And 9 minutes. Page 279
Ah.
starts, my lord.
Served with notices under section 7 within bracket 1. Notices under section 7 within bracket 1 of the 1964 Act on 27 to 2000, notice dated 27 to 2021, indicating the amount of compensation assessed by them. Full stop. On the amount of commissioners who assessed, the petitioners have contended that the assessments were made without following the provisions of the RFCTLARR Act. Full stop. He has submitted that in the areas in the vicinity of the petitioner's parcel of land, there are large scale development and a number of big commercial establishments have already been set up, as evident from the Annexer C series enclosed with the writ petition. Full stop. Annexer C series photographs. Full stop. By making a reference to the provisions of the RFCTLARR Act, it has been contended on behalf of the petitioners that the provisions of giving a hearing to the persons interested, publication of the publication in newspapers to gazettes were violated. Full stop. He has contended that it is settled that the right to be heard against any proposed acquisition has to be meaningful, and the landowners have a right to communicate his objections and concerns to the authority acquiring the property. Full stop. But the steps followed by the responding authorities go to demonstrate that there was no hearing afforded to the petitioners, and in absence of a notice under Section 3 within bracket 1 of the 1964 Act, the petitioners could not communicate their objections and concerns to the requiring requisitioning authority. First of. Yes, anything? Or?
My lord, can it be up to your lordship, my lord?
Uh-huh.
Our hearing was proposal was the both side taking, let me mention.
It is also,
Only our land set taken only one side.
it is also contended that the requisitioning authority had adopted had requisition had acquired parcels of land only from one side of the existing two-lane road for widening it to a six-lane road without touching the other side of the existing two-lane road.
Unlike others, ma'am.
Other side,
Unlike others, all are
First off,
from one.
it is the side where the parcels of land belonging to petitioners which have been brought within the purview of requisition and acquisition. First off, such an approach
But,
is clearly arbitrary and it demonstrated that the
my lord, can one line maybe-
requisitioning authority where requisition and acquiring authority had adopted an arbitrary approach which is clearly bad and illegal. Yes.
And offered amount is 1/20th of the real market value, maybe noted, ma'am.
First off, it has also been urged on behalf of the petitioners that the amounts offered in the notice under section 7(1) of the 1964 Act were grossly inadequate in that, the amounts were assessed, according to the petitioners, for their parcels of land were much lesser, at rupees for 4 lakh,
14 lakhs per biga, my lord.
14 lakh per biga.
40, my lord.
40.
Lakhs per biga.
No, your land. What
Yes.
is the value?
Yes,
They have
my
taken
lord, 14 lakhs per biga, my lord.
14 lakh per biga.
40, my lord.
No,
40 lakhs per
your parcel of land, how much they have
Oh, my
taken?
lord, this is not given, yes, my lord. There is
It's
different amount given, my lord.
No, per biga fixed.
7 notice says, section 7 notice says 2 katha 40 lakhs. 2 katha 40 lakhs. Section 7 notice for 2 katha land, it is 40 lakhs.
My lord, kindly have a look, my lord. I made a chart, my lord.
It is there.
My lord, kindly look at.
It is there, not required.
Yes, yes.
কি করলো? Say rupees 40 lakh per biga. 40 per biga. Whereas for commercial class of land, the value has been taken as 96 lakh per biga. Full stop. As the petitioner's parcel of land due to long disuse have already have already can be classified as commercial class. Therefore, comma, the valuation of their purchase of land at rupees 40 lakh per acre was is grossly inadequate. Full stop. Para. Responding to the submissions advanced by the learned counsel for the petitioners, Mr. Nath, learned senior government advocate, has submitted that in LA case number 12/2024, comma, an area of land measuring 6 bigha 2 katha 14 lesser have been brought under the purview of requisition and acquisition. Post stop. In LA case number 13/2024, comma, the area of land is 21 bigha 7.5 lasas, correct? Full stop. He has contended that he has stated that in LA case number 12/2024, a total of 183 landowners have been enlisted as beneficiaries. Full stop. Similarly, in case of LA case number 13/2024, comma, a total of 729 number of landowners are made beneficiaries. Full stop. It is only the petition number 6 in LA case number 12/2024 and the petition number 1-5 1-5 and the petition number 7-20 who have claimed that they were not served with the notices under section 3 within bracket 1 of the 1964 Act. Full stop. He has submitted that after issuance of notice under section 3 within bracket 1 of the 1964 Act by the respondent number 7, comma, the notices were taken to the localities to be served to the Gaon Pradhan and the process servers.
In presence of Gaon Pradhan.
By the process servers in presence of the Gaon Pradhan of village Mirzapur and village Koral. Full stop. Most of the beneficiaries were served with the notices, and some of the beneficiaries could not be served with the notices due to their absence in the locality.
Refusal. They refused. They refused to sign. Some of them
Full stop.
refused to sign.
In case he has pointed out, he has submitted that insofar as the petitioners are concerned,
And others also.
apart from few others, they refused to accept the notices. Full stop. He has thus contended that such refusal is to be accepted as deemed acceptance of the notices. And therefore, there was no irregularity on the part of the requisitioning and the acquiring authority, requisitioning authority as well as the acquiring authority to take further steps in the requisition and acquisition process. Full stop. After a decision taken to acquire the parcels of land initially requisitioned, Gazette notifications exercising the power under section 6 within bracket 1 of the 1964 Act were duly published and thereafter, the notices under section 3(7) within bracket 1 of the 1964 Act were issued to all the beneficiaries, including the petitioner's hearing.
My lord, two dates may be mentioned kindly, my lord.
I'll mention the dates, sir.
Are being noticed
We are-
according to them.
Sir, why do you in so much hurry? I am recording his submission. Facts, whatever is left out, I'll record in the order. Yes, sir. Something if I miss out, you write in a note, hand it over to me, so that after the finish of one particular thing, I look into it. Right. In the middle, it is very difficult to again recollect. Hearing. First off, he has further contended that the compensation assessed, amounts assessed, and as indicated in a notices under section 7(1) are assessed as per the provisions of the RFCTLARR Act, right? And therefore, the contentions raised by the petitioners regarding gross inadequacy cannot be countenanced. First of all, insofar as the contention raised regarding selective acquisition of land only from one side of the earlier existing two-lane road is concerned, Mr. Nath has submitted that it is after preparation of a feasibility report, the process of acquisition was initiated. Full stop. Since the purpose of the project is to widen the existing two-lane road leading to the airport, LGBI airport, into a 6-lane road, comma, it is the alignment which is within the domain of the experts, comma, is to be given precedence. Full stop. If, as per the feasibility and for the purpose of alignment, only the parcels of land situated in one side of the existing two-lane road are to be acquired, comma, no fault. No, it is not open for the petitioners to raise such ground. Full stop. Mr. Nath, Mr. Nath has further submitted that if the petitioners are aggrieved by inadequacy of the compensation amounts, comma, as mentioned in the notices under section 7 bracket within bracket 1 of the 1964 Act, comma, it is always open for the petitioners to seek enhancement by seeking a reference before the authority. Full stop. He has, in support of his submissions, comma, he has referred to section 12 of the 1964 Act. First of, he has submitted that similar provisions for reference are also in the RFCTLA RR Act as well as in a repealed Land Acquisition Act 1894. Full stop. Making with such submissions, comma, he has submitted that the matter of adequacy or inadequacy of compensation is not to be adjudicated in a writ proceeding under Article 226 of the Constitution. Full stop. Whereas insofar as the contention regarding the classification of the parcels of land of the petitioners is concerned, it is submitted by him that as per the land records, the provisions indicated from the Assam Land Records Manual by the petitioners are not applicable not open for to be agitated, as the Assam Land Records Manual is not a is merely as the provisions in the Assam land records manuals are merely guidelines. Full stop. If the petitioner's parcels of land have had acquired the status of non-agricultural class, then because of long disuse, the petitioners ought to have taken resort to the provisions of the Assam. এখন কত? একটা ছিল? কোথাও বলতো? Assam. Agricultural land within bracket regulation of reclassification and transfer for non-agricultural purpose bracket close Act, 2015, Act 2015. Full stop. Non-disposal of the applications for reclassification in respect of few of the petitioners and absence of applications for reclassification for the remaining petitioners cannot be a ground to assess the compensation amounts in respect to the petitioner's parcels of land as non-agricultural land. Yes. Contra submissions all included?
Well, we have just two things if Lordship may consider, Malad. A value has been considered under 13 Act, Lordship has said, as per zonal valuation, considering the zonal valuation as per the available revenue record. That one. It is written in this.
It is their statement, value of the land in Bigha.
Yes.
Commercial and Bhaba, Nobo agree. It is there.
It is as per zonal,
Uh,
as per zonal valuation and as per the relevant
he has further submitted subpara
existing
that
revenue record.
the valuation of the parcels of land brought under the purview of LA case number 12/2014 and LA case number 13 of 2024 were made as per the existing rates
Zonal valuation.
for different classes of lands, namely commercial, agricultural, etc.
And as per
And
the-
accordingly,
and as per the revenue record. of-
compensation
They are
and the class of land and the compensation amounts in respect of all the beneficiaries have been fixed as per the class of land as in existence in the revenue records. Yes.
My lord, in my additional affidavit in reply, from page 170 to 228, I have annexed that Jamabandi records of neighboring records, adjacent land records, showing that all are converted to paper or tie. I annex the documents, my lord. That kindly may be read.
Okay.
Both the villages, Mirzapur and Gorok.
Taludar লিখিব। Mr. Taludar, by referring to the documents annexed to the affidavit in reply,
AR2, my lord. AR2 series.
which are revenue, which are copies of revenue records, has submitted that the a large area in the vicinity of the petitioner's parcels of land have been declared
Declassified.
and have been reclassified as commercial land. Full stop. It is his contention that by the same parameter, the compensation amounts of the petitioner's parcels of land ought to have been assessed. We come back to anything?
No, well, I have a small prayer, Malad. Well, in the division bench at 2, one matter is fixed, Malad.
If somebody had,
My colleague is there.
who was with you yesterday?
Malad, my colleague, she is there.
And somebody else was there?
Yes, he's Rajiv Borpujari, he was also. Otherwise, they are there.
Some more were there. Who was there? yesterday?
Rajiv Borpujari, he was.
Ah,
there for-
Borpujari was there.
Borpujari was.
Where is he?
He's in the
Okay.
airport.
If he speak,
I'll inform her.
tell him to come.
I'll inform her. Okay.
Yes.
This is my lord. My lord, may I pray for short accommodation with respect to item number 18 of the supply list? May it pleases my lord.
Yes.
My lord, may I pray for short accommodation with regards to item number 18, my lord? Here I am praying for 2 weeks more time to file our affidavit in opposition, my lord.
Item number.
18 of supply list, my lord.
Yes, Mr. Kanodi is there?
His junior is present.
Hmm. Oh, yeah, Miss Poddar, Land Council for the petition is present. Mr. H. Bora, Land Council on behalf of Mr. B. Gogoi.
My lord. Each order, my lord.
Huh?
Each
And
order.
Mr. K. Jain, Land Standing Land Council for the
Respondent number 4, 5.
respondent number
4, 5 and 6.
4, 5 and 6 are present, huh? Stage Bureau, Land Standing Council, Finance and Taxation Department. Has sought for and is granted. Sought for and has sought for and is granted how much time? Affidavit.
Affidavit in opposition, my lord.
To file counter affidavit on behalf of the respondent number.
1, 2, 3, my lord.
Okay, raise the case accordingly after 2 weeks, so the 2 weeks by the office.
Bless my lord.
Interim order, you finish, hello, to continue.
Hello, bless my lord.
Era. Content case to devotion, content case to. Doctor. Content case to. Content case to. When the writ petition WPC number 6374 was filed and moved on 2/12/2024. And came up for consideration on 19/12/2024. The court, while issuing notice of motion, had observed that there shall be no eviction of the writ petitioners without following the prescribed procedure under the relevant statute. It was alleging violation of the said direction, the contempt petition, contempt case number is C number 50/2025 was filed. Full stop. The by subsequently on 18/11/2025, the interim direction passed on 19/12/2024 was discontinued. Full stop. It is in such context, the contempt petition is to be examined. Full stop. I have given due consideration to the submissions advanced by the Land Council Board of Parties. Oh, before that, Mr. Nath, you are for all.
I am representing the department, my lord. My colleague, my lord, not.
Revenue. You represent revenue.
Revenue.
Okay.
If lordship is.
Mr. R. Pujari, Standing Council, Revenue Department.
5 and 6, my lord.
Paying for the respondent number 5 and 6. In number लिखी रखी वो, number लिखी रखी वो, number वो लिखी रखी वो. Give it to the court master by slip.
My lord, the lordship would have required, my lord, gazette notification pertaining to, my lord, LA 12.
Yesterday given, I think.
LA 12 given.
Paying for respondent number
Oh, bless me.
5 and 6. Has submitted in similar lines as Mr. Nath.
I
Who
have, my lord, relied on 2 decisions of this.
who has made submissions on behalf of the respondent number. Oh, he was also for PWD.
No, my
Not-
PWD not.
Senior government advocate and standing counsel,
PWD.
PWD,
My-
for the respondent number 1, 2, 3, 4, 7, and 8. Full stop. I have given due consideration to the submissions advanced by the Land Council for the parties, and have also gone through the readings of the parties from the pleadings brought on record by the parties. So, fair enough. The Assam Land Requisition and Acquisition Act 1964 was enacted to consolidate the law for requisition and speedy acquisition of premises and land for certain public purposes. Full stop. The power to requisition. Requisition or acquisition concept or anything. The power to requisition land has been provided under section 3 of the Act 1964 to the state government or any person authorized in that behalf by the state government. Full stop. Section 3 has entirely provided that if in the opinion of the state government or any person authorized in that behalf by the state government, it is necessary so to do, comma, for the purposes mentioned herein, comma, the state government or the persons who authorize, as the case may be, comma, may by order in writing, requisition any land or may make such further orders as appear to it or to him to be necessary or expedient in connection with the requisitioning. Full stop. An order passed under section 3 is to be served in a prescribed manner on the owner of the land full stop. When the order for requisition is made by any authority other than the state government, comma, any person interested in the land, comma, may appeal to the state government in a period of 30 days from the date of service, and the decision of the state government in such appeal shall be final. Rule 4 of the 1964 rules has laid down that an order of requisition under section 3 shall be in form B as far as may be, comma, with such modification, comma, if any, comma, as may be necessary. Full stop. those 3-1, yesterday, Mr. Nath showed, where are those? Rule free, okay, okay. A set of notices, comma, in Form B, a set of notices and orders, comma, Form B, comma, stated to have been passed under section 3 within bracket 1 of the Act to 1964, read with Rule 4 of the Rules 1964 in LA case number 12/2024 and LA case number 13/2024 have been placed by Mr. Nath before this court. First up, it is relevant to note that this court, on 18/11/2025, recorded a primacy opinion that notices and orders under section 3(1) Graduate Rule 4 were issued to the beneficiaries and also recorded a primacy conclusion to the effect that also recorded that most of the beneficiaries and notices were brought to the knowledge of the most of the beneficiaries. The notice and order under section 3(1) Act, Graduate Rules so and so. It is averred that notice and the notice order under section 3(1) Rule so and so was issued on 9/7/2024. Full stop. Para. On perusal of the notices, placed before the court by the senior government advocate, it is found that a number of notices, a large number of notices had received the notices, largest number of notices, who are listed as landowner. Had received the notices under their signature. Full stop. A number of other notices. No, yes, so there were no signatures. In case of a number of notices in those notices, and those included the petitioners hearing also. Full stop. It is placed before the court that other than the 20 petitioners hearing whose parcels of land were requisitioned and thereafter, acquired in LA case number 12/2024 and LA case number 13/2024. No other beneficiary landowners, that's beneficiaries, had questioned on the aspect of non-service of the notice and the order passed under section 3(1), read with rule 4. Full stop. From the signatures subscribed in the notices, it is evident that a large number of landowners beneficiaries were served the notices. Full stop. It has been submitted on behalf of the state respondents that a number of landowners as beneficiaries refused to accept the notices. Full stop. Para. Section 4 has provided for the power to take possession of requisition land. Full stop. Where any land has been requisitioned under section 3, the state government or the authorized person, by order in writing, can direct the owner comma, the tenant or any other person who be in possession of the land, whether at the time of requisition or at any time thereafter, before the land, whether at the time of requisition or at any time thereafter, before the land is released from requisition or under rule section 8 to surrender or deliver possession thereof to the collector or any other person duly authorized by him in this behalf within such days of the service of the order as may be specified therein. Full stop. Hey, again. When this power is considered vis-a-vis the power to take possession provided in the Land Acquisition Act, 1894, within brackets, since repealed, and in the RFCT LARR 2013 is considered, it is found that as per section 16 of the Land Acquisition Act 1894 since repealed, it is only after the collector pass an award under section 11, he can take possession of the land, which shall thereupon vest absolutely in the government, free from all encumbrances. Full stop. In the in section 38 of the RFCTLARR Act, as per, the collector can take possession of the land after ensuring that full payment of compensation is paid to the entitled person within the time period mentioned therein. Full stop. Thus, there is a distinction in the Act in the Act 1964 in the power to take possession of the requisitioned land. Full stop. The power to requisition, power to take possession of the requisitioned land as per the 1964 Act gets operational as soon as an order under section 3 of the is passed. Full stop. Para. As per subsection 1 of section 6, where any land has been requisitioned under section 3, the state government may use or deal with it in such manner as may appear to it to be expedient, and may acquire such land by publishing in the official gazette, a notice to the effect that the state government has decided to acquire such land in pursuance of the said section. Full stop. Where a notice as aforesaid is published in the official gazette, The requisition land and premises shall, on and from the beginning of the day on which the notice is so published, vest absolutely in the state government, free from all encumbrances, and the period of requisition of such land shall end. Full stop. Subsection 3 of section 6 has laid down that subject to provisions of the Act 1964, on such vesting, the provisions of the Land Acquisition Act 1894, with the rules framed thereunder, shall, so far as may be, apply to such land. Full stop. The state government this is for your benefit. This is for his benefit. The state government, in the Revenue and Disaster Management Department, by an order dated 8/5/2015, had declared that for land acquisition in the state of Assam, the state government would go by the provisions of the RFCTLARR Act. And in cases where land is acquired under the Act 1964, all benefits like additional compensation, rehabilitation to displaced persons, and protection to landowners as provided in the RFCTLARR Act would be provided. Full stop. It has been it is noticed that after the order under section 3, 3 within bracket 1 dated 9/7/2024, a decision to acquire the land under section 6(1) for the parcels of land brought under the purview of LA case number 12/2024 and LA case number 13/2024 was taken on 18/7/2024 By notification number, এই দুখনত আছে হা, এই দুখনত আছে। LA case number 12/2024/565 and LA case number 13/2024/566. Full stop. By the notifications, it was notified that in pursuance of Section 6 of the Act 1964, the state government had decided to acquire the parcels of land described therein, had acquired them from the date of publication of the notice under requisition under, no, English. Requisition under section 3 within bracket 1. For converting the existing two-lane road connecting LGBI International Airport, Guwahati, from VIP Junction to 6-lane road under the PM Divine, DEVINE program and SOPD within bracket Z. Full stop. The notification pertaining to LA case number 12/2024 by the notification. An area of land measuring 6 biga 2 katha 14 lesa has been shown to be acquired. On the other hand, by the notification pertaining to LA case number 13/2024, an area of land measuring 21 biga 7.5 lesa has been shown to be acquired. Full stop. As mentioned above, the petition number 6 parcel of land has been acquired by LA case number 12/2024, and other petitioners parcels of land have been acquired by LA case number 13/2024. Full stop. The two notifications were published in the Assam Gazette in its issue number 301 and 302 on 25/7/2024. Full stop. From the above, it is evident that the requisition process initiated on 9/7/2024 seized on and on and from 25/7/2024, the parcels of land which were earlier requisitioned, by virtue of Section 6 within bracket 2 of the Act 1964, got vested absolutely in the state government, free from all encumbrances. Full stop. Para. The definitions of the expressions. Requisition and acquisition. Yes, Mr. Uzuri, are they provided in? No, are not provided in the Act 1964 Order Rules 1964. Full stop. However, the expressions are however,
The principle of, my lord,
the two
determining
concepts
it is-
of acquisition and requisition in Keval Chand Mimani versus SK Sen 2001 6 SS 512. It has been observed that the two concepts of acquisition and requisition cannot but be ascribed to be totally distinct and independent. First of, whereas the acquisition involves an element of permanency and finality, informing a transfer of title, comma, semicolon. The concept of requisition is merely to take over the domain or control over the property without acquiring the rights of ownership and must be, by its very nature, be of temporary duration. Full stop. Normally, the expression, requisition is taking possession of the property for a limited period. Full stop. In requisition, the property dealt with is not acquired by the state, but is taken out of the control of the owner for the time being for certain specified purposes. Full stop. Yes, yes. Yes. Para. Oh, no, it is held in Diwani Kumar Paraki, 1984 forest. That where the government having alternative power either to requisition or to acquire the property for a public purpose, suggests the former measure for its permanent requirement, then the requisition would be vitiated by malafide and colorable exercise of power. However, in the case in hand, after requisitioning the parcels of land, after showing requisitioning of the parcel of land on 3/7/2024, the notification to acquire the land was issued on 18/7/2024, and thereafter, the notification was published in the Assam Gazette, official gazette on 25/7/2024. Post. Para. It is brought to the notice of the court that out of the acquired land measuring 6 bigha 2 kata 14 lessons in LA case number 12/2024, and the areas of land 21 bigha 7.5 lessa. Similarly, LA case number 13/2024, the petitioners the share of the petitioner's parcels of land is 1 bigha 19 lessons. Right? Yes. Full stop. Section 7. 1 of the Act has laid down that after the publication of a notice under subsection 1 of section 6, the collector has to cause a public notice to be given at convenient places or near the land to be taken stating that the state government has acquired the land and that claims to compensation for all interest in such land may be made to him. Full stop. As per subsection 2 of section 6, comma, such notice shall state the particulars of the land so acquired and shall require all persons interested in the land to appear personally or by duly authorized agent before the collector at a time and place therein, and to state the nature of their respective interest in the land and the amount and particulars of their claim to compensation for such interest. Full stop. Para. In the notices issued under section 7 within bracket 1 of the Act 1964 on 27 to 2025, comma, which were served upon the petitioners as well as other beneficiaries or other landowners, as beneficiaries, comma. The areas of land as well as compensation amounts assessed, areas of land acquired, and the compensation amounts assessed against such acquired land were mentioned, asking the notices to appear personally or duly authorized person before the collector, Kamrup Metro District, to claim for compensation, comma, if any, within 15 days from the date of issue of the notice. Full stop. It is the state respondents have averred that the decision to requisition and acquisition for the parcels of land at villages Gorol, Mirzapur, Dharapur, Kahukusi, and Jugigupa under Ajara Revenue Circle was taken after conducting a joint survey resulting in submission of a report on 28/5/2024. Full stop. The decision to acquire, requisition and acquire the land, parcels of land, was for the purpose of converting the existing two-lane road connecting LGBI International Airport, Guwahati, from VIP Junction to Dharapur into 6 lane under the PM Divine program. Full stop. Accordingly, comma, the notice and order under section 3(1) was issued, notices were issued on 9/7/2024, which were served upon the patadars to the Gaon Pradhan of the villages. Full stop. Did you file any reply to it? Which?
So somewhere they have been whispered that we refuse to accept, my lord. In around 3 affidavits filed here and 3 affidavits filed.
Please take me to the reply.
My lord, page 157 of my additional affidavit in reply, my lord.
Additional affidavit in reply.
Paragraph 6 and 7, my lord.
Additional affidavit in reply.
6,
Additional
7, 8.
affidavit in reply.
Please.
Additional.
And also the violation of Rule 11, my lord. How to serve notice. Order.
Such assertion made on behalf of the petitioners have been refuted, made on behalf of the state respondents, have been refuted by the petitioners. Saying that, stating that the notices which were the state respondents who were required to serve the notices of requisition mandatorily on the landowners was not done at all. Full stop. Whereas such issue regarding service or non-service of the notice and order under section 3, read with rule 4, are to be is to be examined in the context of the materials on record, full stop, as mentioned above, comma, there were 183 number of beneficiaries in LA case number 12/2024 and 729 number of beneficiaries in LA case number 13/2024. Full stop. Other than these 20 petitioners, comma, who are from about 6/7 families, comma, none of the other landowners stroke beneficiaries whose names appeared in the consolidated notice. Yes, some of whom had subscribed their signatures therein, and some of whom who had not subscribed their signatures therein. Yes. Did not raise any protest in the subsequent period that they were not served with a notice under section 3(1) Redwood Rule 4. Full stop. In the, from such perspectives, comma, this court is not agreeable to accept that no endeavor was made by the state respondents to serve the notice and order under section 3, Redwood Rule 4 upon the petitioners. Full stop. Yes, what decisions you want to show?
Two decisions, my lord, I had.
If you just add weight without any value, then no. If he adds weight with value, if there is value addition, give it.
Yes, my lord, only with regard to quantum, because they have put a challenge with regard to the.
I'm observing it. It will be,
Classification.
that is why I made this,
Yes,
that
yes.
LARR Act is applicable so far as quantum. We have to deal with this classification issue also.
Yes.
Thereafter, anything left, whether,
Only with regard to the quantum vis-a-vis classification. To that extent, two decisions, my lord, it is there on record, my lord.
okay.
Yesterday I
Give
had.
Sigva?
Yeah, my lord, one is of the apex court, my lord, land acquisition officer P. Talai Reddy, and one is, my lord, that Amulya Mohan Das.
New song.
Manupatra, full text, my lord, I had. Let's see if we can keep this, my lord, I have two extra.
Porason, Porason,
One.
Porason.
Lordship, may kindly be pleased to peruse this, my lord, I have copies.
You have given.
Two,
We have it, we have it.
one is my lord Amulya Mohan Das. That is by this honorable court, my lord. Why, my lord, the parameters to be considered for.
But the section.
The next issue, which has fallen for, there are many issues you have raised, I have to deal one by one.
It's only rule 11.
Only two.
The next issue which has fallen for consideration is regarding the allegation of requisitioning and acquiring parcels of land only one side of the then existing two-lane road from VIP Junction to LGBI International Airport.
Hello. Dharapur, via LTBI.
This is the land, maybe by Dharapur, whatever. Full stop. Mr. Talukdar has raised the contention that there are large establishments on the other side.
My lord. Yes, my lord, surrounding.
No, surrounded. In the other side, there are large establishments.
No, my lord.
That is not the case.
Vacant land, my lord.
Huh?
Vacant land. That's why.
Okay. Full stop. The respondents the state respondents had made a joint survey. The state respondents stated to have made a joint survey. With the requiring department, Public Works Department, roads, prior to initiation of the requisitioning and acquisition process. After conducting a joint survey, resulting in a report dated 28/5/2024. Full stop. From an office letter dated 11/9/2024. Of the respondent number 7, addressed to the requiring PWRD, Roads Department, Public Works Roads Department. It can be noticed that parcels of land were acquired not only from the two villages, Das Gorol and Mirzapur, where the parcels of lands of the petitioners were located, but from 4 other villages. Full stop. The details of the acquired land village-wise can be seen where as follows. Running page 182, table of marks. From the above fact of acquisition of 51 bighas, 3 kothas and 6.75 lasas for conversion of the then existing 2-lane road connecting LGBI Airport, Guwahati from VIP Junction to a 6-lane road under PM Divine Program and SOPDG. It was not only the petitioner's parcels of land were necessary. Full stop. From the fact of acquisition of 51 bighas, 3 kathas, 6.57 lasas in total, it can vary, it can be easily noticed that it is the feasibility and alignment of the road from 2-lane to 6-lane through 6 villages, which are to be kept in consideration in the process of requisition and acquisition. Full stop. The matters of feasibility and alignment lies within the domain of experts and the court sitting in rich jurisdiction does not have the expertise and domain knowledge to comment on the feasibility and alignment of the road, of the widening, conversion and widening of a two-lane road into 6-lane road, which are leading to an international airport. Full stop. If in the process of such acquisition of land, keeping in mind the feasibility, keeping in mind the aspects of feasibility and alignment, comma, if the parcels of land belonging to the petitioner, comma, incidentally on one side of the then existing two-lane road, comma, had been bought under the purview of LA case number 12/2024 and LA case number 13/2024. Such issue without any further supporting and convincing material, comma, is not an issue to be adjudicated in writ proceedings under Article 226 of the Constitution of India. Post of. Para. Rule 23. Comma Rule 59 and Rule 74 of the Assam Land Records Manual are have been referred on behalf of the petitioners to claim that the same cast an obligation on the part of the state to convert lands, to convert agricultural land, lands which are classed as agricultural land to non-agricultural class due to non-use for long periods, right? Full stop. Rule 23 has provided that the recorder during his winter tour is required to make a list of all fields which have been converted from agricultural to non-agricultural use and are liable to be altered or additional assessment under the rules framed there under. Like, full stop. The provision in Rule 23 itself indicates that the recorder has to make a list of all fields which have already been converted to non-agricultural use from agricultural use. Full stop. A recorder does not have any power and authority on his to convert any land from agricultural use to non-agricultural use. Full stop. It is only after conversion of a plot of land into non-agricultural use, the recorder has to make assessment for has to do additional assessment as per the rules framed therein. Closed. Rule 59 has men has provided for making a record of land use as per current utilization. And in the record, comma, the class of land use, sorry, land is to be recorded depending on the use. That is, comma, forest, comma, barren and uncultivable land, comma, land to put non-agricultural uses, comma, etc., comma, current fellow, FALLO, etc. Rule 74 was provided that in the Jamabandi, comma, in the relevant column, the annual Jamabandi is required to be filled up from the relevant column of the CETA in accordance with the nature of land use. Full stop. The provisions of Rule 23, comma, Rule 59 and Rule 74, comma, when read together, comma, do not go to show that those provisions, under those provisions, comma, the revenue authorities have been mandated, have been obligated to change the class of the land, to convert the class of the land from agricultural land to non-agricultural land. Only noticing its non-use for a long period. First stop. Para. So this is new act, 2015.
Yes.
No repeal clause.
No.
So meaning that it is very new act. Earlier there is nothing.
Earlier there was a, my lord, 3 years.
In any pivotal matter. In the considered view of this court, the provisions of Assam land record manuals are not statutory prescriptions. If the provisions are do not have any statutory prescriptions, comma, and are merely in the form of guidelines and instructions, then the same would not be enforceable. Full stop. Para. It is the Assam agricultural land within bracket regulation of reclassification and transfer for non-agricultural purposes within bracket close, comma, Act 2015, which has been enacted by the state legislature to regulate the reclassification and transfer of agricultural lands for intended non-agricultural purposes in the state and for matters connected therewith or incidental thereto. Full stop. The definitions of agricultural land comma non-agricultural class comma non-agricultural purpose and commercial purpose, etc. Have been defined, are provided therein. Full stop. As per section 2 small y, comma, reclassification means change of land use from agricultural purpose to intended non-agricultural purpose, intended to bold, and quote unquote reclassified class land means land for which permission under the Act is granted for use for non-agricultural purposes. Full stop. It is the owner as defined in section 2R, comma, who has to express the intention for reclassification, for change of use of his land from agricultural purposes to non-agricultural purpose, and to seek for such reclassification as following the procedure for reclassification laid down in rule section 5 of the Act. Full stop. Subsection 1 of section 5 has prescribed that any owner of agricultural land who intends to reclassify or reclassify come transfer, not like it. Transfer is not here, to reclassify agricultural land for non-agricultural purposes shall have to make an application to the jurisdictional deputy commissioner, giving full particulars of his land and justification of the proposed reclassification in such form and manner as may be as prescribed. Full stop. Section 3 of the Act 2015 has placed a bar in the form that no person shall use or transfer agricultural land for intended non-agricultural purposes without reclassification and permission in the manner laid down in the Act. Full stop. Thus, comma, the concept of reclassification of agricultural land to use the land for non-agricultural purposes would get operational only when the owner of the land himself expresses an intention and shows justification for such reclassification, meaning thereby, comma, the reclassification, the process of reclassification is to be initiated from the end of the owner. Full stop. Para. It is stated by the petitioners that some of the petitioners, prior to initiation of the process of requisition and acquisition, had submitted applications for reclassification. Full stop. It is contended by the learned counsel for the petitioners that due to initiation of the process of requisition and acquisition, comma, those applications might not have been processed. Full stop. if those petitioners who had already applied for reclassification of their respective parcels of land can establish that the reclassification did not happen due to inaction on the parts of the authorities under the Act 2015. এখন আমি reclassification act করে দিব short. Under the reclassification act, then those petitioners may have a case for consideration of their respective parcels of land for assessment in that manner. Full stop. But such a fact has to be established by leading evidence to that effect. Full stop. If such a contention is raised, comma, it would also be open for the respondent authorities to rebut the claim. Full stop. Such determination of facts could not and would not be adjudicated by this court in this writ petition, in this jurisdiction, which is only a supervisory jurisdiction. Full stop. Non-adjudication of such claim of the petition would not, comma, however, comma, preclude those landowners, petitioners to raise such a claim before the appropriate forum. Full stop. Before the appropriate forum. In such view of the matter, comma, any observations made in this order shall not be construed as observations on the merits of the claim of the petitioners regarding reclassification of their land.
Section
I am not observing anything.
Section 9, my lord. It may be seen, my lord.
No. I'll come to that. That referral part, I'm coming to that. This reclassification, I am keeping it open for you.
He could have done it, but the
No.
section 9. 9, my lord.
Section 9 of what?
The Reclassification Act. Have a look, man.
Section 9 has provided so motu power to the deputy commissioner to reclassify any agricultural land. Post of section 9, which is with a non-obstante clause, comma, has provided a power to the deputy commissioner to reclassify any agricultural land where a non-agricultural activity has already been established before the commencement of the Reclassification Act 2015 under the existing laws, comma, for the purpose of revenue assessment, comma, up to a maximum period of 60 days from the date of commencement of the Reclassification Act. Full stop. From the very provision itself, comma, the power under section 9 is a discretionary power available to the deputy commissioner. Full stop. It is for him to reach a view that in the concerned land classified as agricultural land, a non-agricultural activity has already been established before the Reclassification Act. Full stop. Coming back of full stop, in having regard to the ambit and scope of the power of judicial review, comma, the contention of the petitioners, contention advanced on behalf of the petitioners that the deputy commissioner, jurisdictional deputy commissioner, did not exercise the discretionary power in respect of the petitioner's parcels of land cannot be considered because it is the jurisdictional deputy commissioner who has to record a finding, reach a finding that a non-agricultural activity has already been established, which in turn again require determination of facts.
Admittedly, it is not there. Their own representation requesting that the deputy commissioner to reclassify the land says, well, surrounding lands are being, well, industrial activities, commercial activities is done in surrounding land. So kindly change the land. It is not their case that their land has been.
Let us not deal into it.
No, no,
It is
you have
open for
mentioned,
them.
my lord.
I am not.
Lord, stoves and hotels are running is mentioned and Jirat is given, my lord.
Lead evidence, sir. That is why I am not commenting. If I comment, referral court will not give you anything. Have you understood?
Yes.
That is why I kept it open to lead evidence that this 5-star, that 5-star, this big school, that big school were near our parcel of land. So our market value is 1 crore. You can ask for 5 crore also. That is for the court to decide. I am not commenting on it. If you insist for comment, then it will be very difficult. Reclass. Para. The acquiring authority, after exercising the power of acquisition under section 6(1) of the Act 1964, has already proceeded to issue the notice under section 7(1) of the Act 1974 to all the beneficiaries whose parcels of land, landowners beneficiaries whose parcels of land have been acquired classified LA case number so and so and LA case number so and so. Full stop. The petitioners were served with such notices. Full stop. The petitioners have said that the compensation amount indicated in a notice under notice dated 27/2/2025 issued under section 7(1) of the Act are grossly inadequate and the same have not been assessed following the provisions of RFCTLARR Act. Full stop. It is also contended, it stands iteration that the petitioners have contended that the market value of the petitioners' parcels of land are much higher than rupees 40 lakh per bigha, as the petitioners can establish from
Exemplar deed, my lord.
no,
Yes,
But,
exemplar deed, sale deed, my lord.
Last 5 years.
yes, that is what I.
Last 5 years sale it including the.
He has not
location
contended,
and-
I am keeping it open.
My lord.
From the
It is-
land transactions occurred in the vicinity
Yes,
of the petitioner's parcel of land in the preceding years,
yes,
that the market value ought to have been taken at a much higher value than the general valuation as contended on behalf of the state respondent. Full stop. But having considered these submissions regarding gross inadequacy of the compensation amount, comma, this code is of the unhesitant view that such issues and claims are to be hesitated by the petitioners, are not to be hesitated in a writ petition, and the same are to be hesitated in the appropriate forum, in an appropriate forum. Full stop.
Section 12, madam.
In this connection, it is pertinent to mention that section 24 of the Act 1964 has provided for reference to the court in the event a landowner beneficiary is not satisfied with the amount of compensation assessed. Full stop. The provisions in section 12 of the 1964 Act is similar to section, what is the RFCT? 64,
64.
perhaps,
Yeah.
64.
No, but I'm having it.
64 of the RFCTLARR Act. 64?
just 26 perhaps.
64.
64. 64 of the LAR Act. Full stop.
Here perhaps, my lord, with all respect, it will be section 12.
I'm keeping it open, both 12 and 64.
12
He
and
can
16.
hesitate, he can hesitate.
Yes, yes, yes.
I am not commenting
Yes,
on it.
yes, my lord.
You argue both
Yes,
there, you
yes.
fight it out
My-
there,
My lord, my lord.
right?
My lord.
Whether
No, my lord.
12 will apply or 64 will apply.
I'll be the last person to argue here, my lord.
Huh. No, you argue there.
Yes, okay, yes, lordship is correct.
As such issues and claims are to be agitated before an appropriate forum, this court is not making any observations on the aspect of adequacy or inadequacy of the compensation amount assessed against acquisition of the petitioner's parcel of land. Post of the petitioners are therefore at liberty to raise such issues and claims before the appropriate forum. Post of para. What left?
My lord, small to prayer, my lord, I may be allowed to draw the amount offered within a reasonable time. And my lord,
If it is pertinent to mention that even if the petitioners are not satisfied with the compensation amounts assessed by the acquiring authority, and as indicated in a notice under section 7(1) of the Act 1964, it is still open for the petitioners to receive the said amount, recording their protest, thereby reserving the liberty to approach the referral court, to ask for reference, raising the issues and claims regarding inadequacy of the compensation amount assessed. Done?
my lord, we will
One
file-
more.
My lord, according to your lordship's direction, we'll file, my lord, but in after filing, my lord, can be recorded, it should be sent because, my lord, in my note, I have mentioned.
You
that-
file within
My lord,
31 day, 31st day you come.
My lord, kindly, the 97, till since 97, we are suffering, 95, my lord, we are suffering, same people's set of others.
Oh, you come there for
No, my
us
lord,
to.
only so that they will not harass.
You come
You
come
give
with the other, that money you are not paid. Money were not paid in respect of previous to acquisition process. You come in a,
My lord, only.
you
only-
come, please
only-
come.
My lord, only so that.
We
they
are
cannot
inviting
repeat-
you.
My lord, only that they cannot repeat it with us, my lord, only for that, my lord.
Ah.
Give some time limit, my lord.
When statute provides, court does not provide. I am inviting you to come,
My lord.
alleging inaction in the on the part of the state in releasing the amounts in respect of the previous to acquisition process.
My lord, only thing is that, my lord, that DC may be directed.
This
my
has,
lord, with a time period, my
the
lord, to
prayers
send it.
in this petition
My lord.
has no connection whatsoever. So we do
And-
not want to
and-
make
and-
additional
And my
comment.
lord, only two, my lord, if we.
The other contentions, Mr. Taludar has sought to raise other contentions
No, my lord, no other.
which are found to be irrelevant
No, my lord,
for adjudication of the prayers made in this writ petition. And therefore, the same are not discussed
my lord, reclassification at least.
for the sake of brevity.
My lord, for the only reclassification, my lord, we will file, my lord, then it may be considered within a time limit, my lord. That is all. Otherwise, they will keep it for years, my lord.
No, I have kept it open. I've said.
Yeah, open, my lord, but they will not consider it.
No,
for-
no, regarding that, see,
a time
Mr.
limit, my lord.
Taludar, I have to keep in mind section 6. It got vested with the state free of all encumbrances on an effect from 25/7/2024.
Well, that's
I have
true.
to keep in mind, sir.
My lord, that is true, my lord. But thing is that.
That is why I consciously recorded it.
Yes, my lord. But my lord, only my lord, they will make. a
I have
suffering.
made also the distinction with 1894 Act and 2013 Act. That is why I consciously recorded
Very
it.
much, my lord, very much obliged for that, my lord, and very much, my
Having-
lord, true, my lord, only, my lord.
Having
only
this
Mr.
writ petition, uh, in the light of the discussion made above, okay, a last line to kati dibo. E11 to kati dibo. Otherwise that will again cause him prejudice. In the light of the discussion made above, and for the regions assigned therein, comma, the reliefs sought in this writ petition regarding, the contentions raised regarding issuance of the notice, non-issuance of the notice under the Act 1964 and the Rules 1964 is found to be untenable. Full stop. The claim regarding reclassification of the petitioner's land are left open for examination in terms of the observations made above. Full stop. The direction sought for to the state respondents to acquire equal proportion of land from both sides of the middle point of the existing two-lane road leading to the airport through village Goral and Mizrapur is found to be one which is not appropriate to be examined under article in exercise of power of judicial review under Article 226 of the Constitution. First of resultantly, with the resultantly, comma, the relief sought for in the district petition by the petitioner are found not to be allowed. Full stop. With the observations made above, so that open
Yes, absolutely.
observations made above, the writ petition is dismissed.
My lord,
Shall-
obliged, my lord, only a direction to the
He-
DC,
order-
if no file to within a time to consider, my lord. Otherwise it will kept, my lord, for years, my lord. Be suffering the same thing.
That is not the
There
direction.
is a,
We, after filing of the, my lord, for reclassification under as per 15, we'll file it within a time limit. And then to only to consider within a time limit only.
child is not yet born, my lord.
I gave it a thought.
Child is not yet born.
I gave it a thought whether it could be given. I have tried to give as much leverage to you as possible. But it is still open. You get it reversed and with better directions from a higher forum. It is still open for you because the other already you have filed. Same
My
petitions
lord,
are before the division bench.
if we are given the relief, my lord, yeah, we'll withdraw it because.
No, I could not. My hands are tied.
No, my lord, that's true, my lord. But only thing is that they will keep us harassing us for another for years more. My lord. That is the only
Yes.
our worry, my lord.
But it could only possible be on Monday. Uploading.
No difficulty, my lord. No
Right.
difficulty.
I must say.
My lord, no problem.
my lord, and the connected contempt has become
Oh,
infectious.
before that, before that,
Dismissal of the repetition.
before that. Tolot. In view of the dismissal of the repetition, comma, the interim order stands, if any, stands recalled. Interim order is not there.
But
No.
contempt lordship.
In the, from the facts and circumstances, before it last agot, from the facts and circumstances obtained the case, comma, as discussed above, comma, it is found that the procedure laid down in the Act 1964 and the Rules 1964 were apparently followed, were followed for requisition and acquisition of the petitioner's parcel of land. And as such, comma, there is no, this court finds no violation of the direction made in the order dated
23.
initial order,
Initial.
1912.
Justice Soikia,
1912-24.
which in any view of the matter, comma, was recalled subsequently on
1811.
1811.
দুইটা চাই ল'ব হা দুইটা চাই ল'ব আগত কৈছো does comma the contempt petition alleging violation of the interim order dated so and so stands closed. Like তাৰপিছত I
And so, like,
Ordered matter, item 15.
for 10. Thought it 3
Made,
but
please.
could not.
Made, please, your lordship.
কালি বহুত দিলে না বহুত দিলে না কালি এটা
Made, please, your lordship.
it will not be possible to end today to complete dictation.
Or any other day, my lord.
Because I have,
Tuesday, my lord.
my things are also
Yes, yes.
thirsty. 16 Partha,
Well,
because next week I'll not be here.
I'm not available from 10 to 16, my lord.
I have to dictate only.
Yes, yes. My junior will be there, yes.
Your submissions are recorded.
Yes, yes.
Good, some written submissions have also come from you.
Lordship, we have submitted on
Okay.
4 contention.
Petition.
Yes,
So, otherwise you will go up to 5
Yes.
from petitions. This is your written submission.
Indeed.
Okay. Put it as Partha on 16. We'll take up at 2, we'll say 2. Yes, Mr. Henry? TL Oscar?
Yes.
I got it. Due to paucity of time, the case will not be taken up. They list the case on 16/12 as part of case will be taken up at 2.
Much deeply applied.
Highly.
Item 16.
May
it please your lordship.
Yes.
Your lordship, in this matter, we could not settle the claim because the petitioner did not submit some vital documents. like claim
And the
for.
question I asked is that whether in a writ petition this can be enforced.
Your
Anyway,
Lordship, I believe that
can
there
you
is no-
file?
No.
Can you
Your Lordship,
file
we
your
did not file the affidavit in
counter?
Yes,
Can you file your counter
yes, Your Lordship,
at
within
the earliest?
next week.
Okay. There is no representation. Maybe he has lost interest. But we
It's
are,
an old matter.
this matter is on board.
Okay, Your Lordship.
There is no representation on behalf of the petitioner today on call, Mr. S. Dotto.
Yes.
Learned Council appearing for the respondents has sought for a week's time to file a counter on behalf of the respondent insurer. First of, release the case on 17/12.
Item 17.
Where is Mr. Sahu? Huh? Yesterday he was there. So benefit of doubt. I have heard him, so we'll put it in the next week. Mr. S. Sahu, Learned Counsel for a petition. He's okay. The Learned Counsel for a petition is found today absent today on call. Full stop. Let the case come up for ends of justice be listed on. Did you 15? Did you 15? 15. 15. Maybe because of Thursday, he is not interested to have dismissal. He was avoiding.
Item 19.
Yes, Mr. Ranchuri.
May it please, Your Lord.
What is the matter?
Matter, my lord, Shamaboy Shomiti, there was a FIR against the secretary.
Oh, wow.
My lord, during the pendency of the challenging the suspension.
Some
order,
other day, sir.
there was
I make it leftover the parted one. Some other day.
But my lord,
Mr. Ranchuri will argue.
Lordship, this is the order I have.
my lord, they have
Already
withdrawn the revoked the termination order. But my lord, in my petition, there are two prayers challenging the suspension along with the cancellation of this order. So my lord,
PDS license
PDS license.
has been revoked.
That license that was cancelled during the pendency of interim order of the writ petition. Now they have revoked the cancellation, but the suspension continues.
Okay, we'll hear some other day, Mr.
Lordship.
That
My lord.
revocation due to interim order.
Lordship, my lord, that interim order was not communicated to the, my lord, that authority, Lordship, that
No, no.
district commission. So as because, my lord, only because of that, Lordship, they did not have any knowledge regarding the stay order,
No,
the
no.
interim order. So, my lord, this order was passed. Subsequently, they came to know, my lord, that there is an interim order.
Petition was moved in August.
Lordship,
Interim order was passed on
27/1.
4/11/2025.
Lordship, interim
Is it
order
not?
was 27/1, I think. 27/1, 2025.
Huh? 27?
1. Some other case, Lordship, they filed
There
some
were
other case.
Earlier
That is-
petition, the first
That
interim
That
is a
was
different
withdrawn.
one, that is being withdrawn.
Lordship,
withdrawn with a liberty to file.
we were liberty to file, and that interim order, I think, my lord, it was on that matter, Lordship. 5772.
Now he's saying that due to interim order, the cancellation has been revoked, but suspension order still remains,
Lordship.
challenging which he earlier filed a writ petition.
My lord, that interim order,
Which was
my lord,
withdrawn with liberty.
suspension order, Lordship, that was challenged in earlier that.
Which was withdrawn with liberty. That is
Liberty.
what he says.
And the
But
suspension order is again challenged in this writ petition. Page. My lord, the,
Now, who has suspended your license?
my lord, the suspension order.
By the
By who?
My lord, suspension order is that page.
Basically, Mr. Henry, you have to
207, my lord, page.
license.
My lord, suspension order is at page
Bench
10, 10.
Bench 4.
Could be bench 4.
Bench 4, license.
Page 44 is my suspension order, man.
Before that jurisdictional issue.
Lordship.
My lord, your lordship's jurisdiction is
No.
No,
Your
no.
lordship can.
No, I am bound by roster.
My lord,
I am bound by roster.
I think, my lord, it should be
Presently, I am more
bench 4.
involved with lands.
Bench 4, man.
It is license, bench 4. এটা কি করছে ওর সাইড একটু কাইতো হতে পারে maybe also I don't know it is order passed by authorities under cooperative society. This is passed by cooperative society act.
this is the cooperative society.
No, no.
Not under the PDS, my lord.
Under PDS,
PDS, my
under essential commodity,
essential commodity.
then it is bench 4. If it is registered
Then 5.
or sub-register else, then bench 5.
But I have a cooperative society. So
No,
I- for your
cooperative society will not do. That will not do. That will go under bench 4.
I think by next week,
Earlier,
your lordship may
lordship,
take up
but-
this matter also. Bench 4 may come.
Earlier, it was come before the bench 4.
No, no, in the top it is written as bench 5. But that they do not, where is the order?
Suspension order, my
In
lord.
order, suspension as well as cancellation.
Suspension page 44, my lord. And cancellation is 208, my lord.
After some, will not make any comment, but today is not possible.
My lord, I understand. After such a long day, no.
Reopening? Choose a date,
My lord, come.
choose a date, 6
Before
or 8.
Before vacation, any day.
Oh no, how can it be?
Before vacation.
I can put it next week. I
Next-
don't know.
Next week, next week.
I'm not sitting.
Actually, this matter come to the before Amalot.
As sought for by Mr. P.K. Roy Churi and Mr. You have to file any affidavit.
No, I have filed my.
Regarding suspension,
I
they have
have-
filed earlier writ petition.
Oh, that is gone.
It
Well,
is gone.
Those affidavits remains, well, the same thing, well, same argument.
I have received the instruction only because of that, my lord. I have discussed with them that also.
So when can you file the affidavit?
We did file, we did. It will take time, my lord, 2 weeks. I need.
Without affidavit it is difficult also. Let it be after
My
vacation.
lord, if I can place it,
You were without license since
Now, my lord, they have, that license has been.
Cancellation order has
The
been passed.
suspension has been effected in November two
Because it's not-
thousand twenty-four.
If I. get
Nothing will happen till first of week.
My
first week.
understanding of this PDS, my lord, after 90 days, it is deemed to be automatically revoked. Under the 15(2) of the, that act, my lord, this is after 15 days, 90 days.
Okay, you'll examine, let us on sixth or.
Your lordship may.
P.K. Roy Choudhury, Learned Counsel for the petitioner is present. Mr. J. Henry, Learned State Counsel, has submitted that he has received the necessary instructions to file the counter affidavit and has sought for 2 weeks' time to file the counter affidavit on behalf of the respondent number. On behalf of the state respondents, including the respondent number
Neptune number, lordship,
Three.
three lordships.
3. Full stop. The prayer is allowed, list the case on video. First, because
It one.
My lord, but that without fail, my lord.
No, I will file my lord within.
Daily list for orders, item 3.
is there anything?
So regarding demarcations, we are not satisfied with earlier with the demarcation process because actually no demarcation was
It is
done.
already done.
It is done.
No,
Demarcation done.
let them produce the minutes, lordship.
I am placing the thing, lordship, and this is second time, lordship. Initially, demarcation was done pursuant to the order passed by this honorable court. Thereafter, I have also
file.
again second demarcation, lordship, was also done where some marking were there.
Only some marking, lordship. That is our
So,
objection.
lordship, according to them, we have to erect pillars, which we cannot.
No, this letter is already there.
No, this is second time, lordship.
No.
This one is second time.
Lordship,
No, sir, originally is already on record. The court might not have taken it into account because it is addressed to Deputy Registrar Guwahati High Court.
Yeah, oh, lordship, yes, lord.
yes. Deputy Registrar,
That
Perhaps.
is lordship, lord.
that is.
That is why the court has asked in the order, it is tagged with the case record.
Lordship.
But this kind of addressing directly
No,
is not
it's wrong, it's long.
right.
Wrong,
So
long.
it is observed thereby that I have seen one order.
It should not be, lordship.
Justice Medhi. Let written instruction be obtained in this regard which may be placed for consideration on the next day. I have seen this order.
Lordship.
Yes.
Both sides had agreed. Petitioner side, private respondent. But
We-
this order is directly addressed to the.
That is wrong, lordship. That is wrong. Yes, lordship, this same,
See?
they are not properly
Yes.
guided or instructed.
That is why perhaps court is not taking cognizance of it despite its availability in the record.
Seems to.
And that this is why Justice Medhi has said,
1990.
let written instructions be placed in this regard. He recorded that demarcation has taken place in the meantime, your submission.
Lordship.
And that was this, that is dated 28/8.
28.
Lordship.
He recorded in September. Have you understood?
Lordship.
And subsequently,
That
me, Justice Nair, Justice Ete, nobody has taken cognizance of it. Though the issue has been settled.
lordship.
Issue regarding lordship, we have objection regarding demarcation process, lordship.
Your representative, your representative, sir, madam? Rajiv Fukan. Who is Rajiv Fukan?
Here, repeat.
Huh?
I'm for the petitioner. Contempt. Petitioner.
Amal Bora is represented the.
Who is Amal Bora?
Attorney holder.
Power of attorney.
Oh, he is satisfied.
No, he was not satisfied. He is ready in the,
The-
the demand.
Then file your whatever you want to file.
What is to be done?
File it.
Because lordship.
Bioban affidavit. Lordship, what is to be filed? Lordship? I am
We don't know. I have not opened the matter. I have seen this only.
Yes, Lordship, that is the, because initially one affidavit is filed pursuant to the direction passed by this honorable court in the writ petition. demarcation was done. Accordingly, they are not satisfied. They have filed a writ petition along with a contempt application. In the writ petition, the direction was that as because you have already preferred a contempt application, so you hesitate all these things there.
It petition,
Accordingly, it was withdrawn.
minutes was directed to produce before your lordship. That minutes was not given to the honorable court. We have filed this contempt.
There was some direction to prepare minutes.
Yes, no minutes is given.
Minutes,
Prepare-
lordship,
prepare
most,
minutes. This is not the minutes.
Minutes are there.
No,
No, in demarcation, you do not have to sitting in office chamber, prepare it.
Yes.
That is not the minute.
yeah, there's.
That is not the court's intention. Who is Amal Bora?
Amal Bora is the power of attorney holder of the petitioner.
Second lordship, the petitioner is staying at Ireland. This is.
No, if Amal Bora has made a statement in writing,
Yes.
huh?
He is not.
You get the originals.
Yes.
Get the originals of Amal Bora's statement.
Yes, lordship, it's here, lordship.
He has
It's
stated.
here.
No, but everything addressed to
Yes.
Lordship, that is the previous lordship. The first page is addressed to your lordship. I have made photocopy just because I was under the impression that it was not sent to this honorable court and it was sent to me.
repeatedly for 3 occasions ignored it. I am also ignoring that.
Lordship. Hey, wait, lordship, I
Let
appreciate
them
it.
produce the report.
That is the statement of the Amal Bora. Was not allowed to hold any post, hold and post. Only red marking has been done, for which objection.
Marking was done. How it can be demarcated between two landlordship?
Will hold substantial compliance.
Because
These two old men fighting.
Lordship, that is the, as because we cannot erect lordship, it amounts to position lordship.
Right.
no.
So lordship,
That-
initially it
that-
was shown.
Lordship, that land-
Initially, it was shown that this is your portion. But this honorable court, at least for their satisfaction, make something. But it cannot be reflected in the order, so it was not reflected in the order.
Lordship,
That is why second demarcation, there and the marking was there. Some marks
No
were
marks,
put,
only one
were red mark.
red mark.
Yes, it is reflected here.
Cannot be determined this portion is our portion or this portion their
That
portion.
determination cannot be done. It amounts to position.
Because I am, because I.
That
land
is the
belongs to
problem,
me,
lordship.
There's a,
File an affidavit bringing all this,
yes.
The second one, all these things.
all this.
Lordship.
That will answer everything. Thereafter we'll
Lordship,
decide
Lordship.
whether it is
Because it's a forefathers property.
direction.
Lordship, may I pay the documents which are already sent to the court? It is, can I take back that one? Because it should not be lordship.
Let it be kept. Already taken note of
In that case, lordship.
in the office notes,
Lordship.
right? We cannot.
I will tell them, lordship, not to send the documents directly to the court.
Heard Miss R. Bora, Learned Counsel, for the petitioner in contempt case C number 203/2025. And who else
M. Kalita on behalf of respondent number 2 and 3
in contempt case?
in the contempt petition.
Contempt case.
I am for one. Lord.
Anybody? No. Mr. H. Sharma, Learned Counsel for the respondent number 1 has submitted that he has received the necessary instructions and the documents to file the counter affidavit and has sought for 2 weeks' time to file the counter affidavit. Full stop. Place the case on next year, 9th of January.
Lordship.
For hearing, item number 7.
He's hearing it. Then, morning.
Time is already done, my lord. My lord, as per the previous order, my lord,
there is some direction against the NC Hills to clarify that whether what were the relevant laws as well as the guidelines followed by
Non-payment of
the
compensation.
pilot compensation.
Yes, anything.
Lordship, the council who is engaged in this
Who is,
case,
who is your?
RM Das, sir. He was in the court for a while, but he had to leave, so.
Every day he is living.
Yeah.
Well, that is their.
For some.
Every day he is living. I have found that he.
Last day they are also saying like that.
He always lives.
Some other day, Lordship.
Sigdar. They are Sigdar. Petitioners. J. Henrik, Revenue. Or State. Okay, J. Henrik, Revenue. 1. Torma. Additional Senior Government Advocate. 5 are present. Miss Tinglung. Learned Council. I have to repeat it, same prayer. Earlier also. Has on behalf of Mr. RM Das, Learned Standing Council, NC Hills Autonomous Council has again prayed, like the earlier occasion, for accommodation on the ground of personal difficulty on the part of Mr. Das. Full stop. The court reluctantly accepts the prayer. Full stop. List the case. Again. Maybe Mr. New Year.
No, my lord.
2020 January.
It regards my lord.
No, otherwise, before vacation, it will be, cause this we will have 150 or 200 meters. Reasonable enough. I have recorded reluctantly.
Hearing day, my lord.
Read your hearing day. Please.
Any hearing day of the next week, my lord.
Yes, please, hearing day. 2001-2026. Hearing day, Tuesday.
My lord, can it be before vacation?
Declined. Yes.
I beg apology, my lord. Some calculation went wrong, my lord.
No issue, no issue.
Sorry.
No issue.
Item number 17, my lord.
The fix is 15.
15, yes.
15. On the prayer of Mr. S. Sahul on council petition is the case on 15.
Lordship, I'm sorry. Lordship, that item number 3, Lordship has fixed this matter of 9. May I pray on 8, Lordship? 8 is a Thursday, Lordship, most likely. Much obliged, Lordship.
15. Other matters will not take up. Let it be left over. Anybody for 8 and 9? Will not take up.